Especially when but I think
My please, Lordship.
Yes,
Lordship,
please.
I'd like to mention hearing item number 72, 73, and 74, Lordship, on behalf of Mao Imchen, Lordship.
72.
73 and 74. It's a number that's lateral.
72, 73, 74. Okay. What is your prayer?
Lordship, release the matter after 2 weeks, Lordship.
Lordship, kindly date may be fixed on 21 of this month, August.
Lordship.
Mr. Vijmomi makes a submission on behalf of Mr.
Mao Imchen.
Moimchan, the learned senior government advocate, and seeks adjournment of the case on 21,
Twen-
8, 21. What is 21? Let's see. Okay. 21 is Monday.
Monday.
On 21, 8, 2023. Prayer is allowed. Listed accordingly. Okay.
Lordship, interim order may be allowed to continue.
The interim order passed earlier shall continue till the next returnable date. Okay.
Please, your lordship, I
Yes,
beg to mention item 68. Kindly this matter may be listed after 2 weeks.
M. Kon Jamir.
I intend, your lordship.
Your name is not reflected.
Yes, your lordship. I was on behalf of City Jamir, your lordship.
Yes, Mr. I. Imchin. Legal counsel. Makes a mention on behalf of Mr. C.T. Jamir. The Leonard Senior Counsel for the petitioner and seeks adjournment of the case for
2 weeks, your lordship.
2 weeks. Prayer is allowed, listed accordingly.
Much obliged.
Please, your lordship,
Yes, Mr. Joshua.
my lord, may kindly allow me to mention the items from 37 to 56. Your lordship, I have received the affidavit filed by the state respondents. And I thought I will.
37.
Yes, 56, lordship.
What is the matter about?
Lordship, this is whether the earlier appointed 2010 to 2013 batches who are supposed to be, who were termed as RMS employees, whether they are actually state employees or they were appointed under the scheme. In fact, that as far as that issue is concerned, this Honorable Court has already decided that they are state employees, but not by the latest seniority list. They are not included. Not only that, the service is supposed to be incorporated into the state cadre with effect from 21/4/2022, lordship. If that happens, they are losing the entire seniority, lordship. After this Honorable Court has decided the issue, state has gone back, their affidavit amounts to perjury, and I have to file a befitting reply, lordship.
Item
37 to 56, my lord.
37 to
56.
Mr. Joshua Shakti. The learned counsel for the petitioner. Submits that. He may be allowed 2 weeks' time,
3 weeks, my lord.
3 weeks' time. To file affidavit in reply. To the affidavit in opposition filed by the state. Prayer is allowed, listed after 2 weeks.
I'm obliged, your lordship.
May I please, Lordship.
Yes, please.
Lordship, I beg to mention hearing item number 69 on behalf of my
Six.
senior Mohajamir. Lordship, my senior has some personal difficulties to take
On behalf of
Mohajamir.
Mohajamir.
Lordship, let the matter come up after 2 weeks.
Mr. So-and-so. Learned counsel. Makes a mention on behalf of Mr. Mohajamir. The learned counsel for the petitioner. And seeks adjournment of the case for 2 weeks. Prayer is allowed, listed after 2 weeks.
Lordship, similar prayer for item number 77, hearing item number 77.
Yes, please. Okay, similar prayer, 77.
Much obliged.
My please, your lordship.
Yes,
Lordship, I beg to mention hearing item number 70 on behalf of V. Definite. Since you could not able to turn up, kindly list the matter after 3 weeks, lordship.
Mr. So-and-so. Learned counsel. Makes a mention on behalf of Mr. V. Devnath. The learned counsel for the petitioner. And seeks adjournment of the case for 3 weeks. Prayer is allowed, listed after 3 weeks.
Much obliged.
Please, your lordship.
Yes, please.
Your lordship, I beg to mention item 71.
Item 71, okay.
Your lordship, since the leading counsel is out of station.
Who is the leading counsel?
Senti Young.
Okay. MS so-and-so. Makes a mention on behalf of Mr. Sinti Younger, the learned counsel for the petitioner, and seeks adjournment of the case for
2 weeks.
2 weeks. Prayer is allowed, listed after 2 weeks.
Much obliged.
May I please, your worship?
Yes.
Worship here in the IN number 92. Worship here, this application has been filed by the applicant for under section 5 of the Indian Limitation Act for consideration of 108 days delay.
Heard, Mr. So-and-so. Learned counsel for the applicant. Stop. The present application has been filed under section 5 of the Indian Limitation Act 1963, praying for condoning the delay of 108 days in filing the connected appeal. Stop. Issue notice to the respondents, returnable within 4 weeks. The learned counsel for the petitioner, for the applicant, shall take steps for service of notice upon the respondents by registered post with AD within a period of
4 days, your worship.
within a period of 4 days from today. Listed after 4 weeks. Okay.
Right, my lord.
Yes. I think. Yes, ma'am.
Please, your lordship, the petitioner has filed this affidavit under section 439 of.
Who is the PP? Miss Mary?
Lordship.
Produce the case diary. When?
After 2 weeks. Your lordship, there is an interim order if the court may allow to.
Interim?
Lordship, interim may be considered on which
Lordship.
date, your lordship. Because without.
This is bail application.
Yes,
Yes, lordship, but.
Heard MS so-and-so, learned counsel for the applicant. MS Mary. The learned PP shall produce the case diary on, give a date,
yes. 28, your lordship.
on 28/8/2023. Yes, yes.
Lordship, the respondent counsel comes from Gauhati. So he has made a request to me to fix it on 17. They have,
The counsel for both petitioner as well as the respondents. Okay. When can you have it?
on Thursday, the 17th.
Thursday. I think it will be a little difficult for this court. Give another date, next week, Monday, Tuesday.
Lordship, that is the request he has made to me. Apart from that, I will not do.
On the prayer of the learned counsel for the parties. Listed on 21/8/2023. Okay. Yes, Mr. Rich Mo. Yes.
Your lordship, I would like to mention for respondent number 5. That is the BSNL. Yes, the previous council expired.
Respondent number, let me just. Okay,
Yes, your lordship, the previous council expired and so the BSNL have entrusted this case to Advocate YP Gupta. And then the Vakalatnama will be filed today. So if you could kindly give 2 weeks time for admission.
have you filed your counter?
Pardon?
Has the respondent number 5 filed the counter?
I have no information regarding.
Who is the counsel for the petitioner?
Your lordship, and the counsel for the petitioner.
Okay, okay. Mr. So-and-so. Learned Counsel submits that Mr. Y.P. Gupta, the Learned Counsel, shall be representing the respondent number 5, and therefore 6 for 2 weeks' time to file power. Wakalat nama.
Yes, sir.
To file power and to receive necessary instructions. Prayer is allowed, listed after 2 weeks. Okay.
May I please, Lordship?
Yes,
Lordship, kindly grant me 2 weeks' time to file my affidavit in opposition.
you are for respondent number, or you are for petitioner?
Petitioner, my reply.
Affidavit in reply to whose?
To the state government.
Mr. So-and-so. The Learned Counsel for the petitioner submits that he may be allowed 2 weeks' time to file affidavit in reply to the affidavit in opposition filed by the state respondents. Prayer is allowed, listed after 2 weeks.
What's up?
Yes,
Your readings are completed, so let it be listed for hearing.
okay. The Learned Counsel for the parties submits that pleadings are completed and therefore the matter can be listed for hearing. Listed for hearing in the usual course.
Yes, Lordship, I mentioned
Yes.
on behalf of Ms. Lucino for the petitioner. She has some personal difficulties today, so if this matter can come up after 2 weeks.
After 2 weeks. MS Senso. The Learned Counsel makes a mention on behalf of MS Lucino, the Learned Counsel for the petitioner, and seeks adjournment of the case for 2 weeks. Prayer is allowed, listed after 2 weeks. Okay.
May I please, Lordship?
Yes,
Lordship, I'm standing on behalf of VDF, not Lordship. Kindly list the matter after 3 weeks.
May it please your lordship.
yes, please.
Lordship, I'm for the respondent number 1 to 6.
1 to
6.
1 to 6, okay.
Lordship, in this matter, the bleeding has been completed. And then the LCR is also there, so,
Okay, LCR is that?
yes. Sir.
LCR?
So Lordship, let the matter be posted for hearing and then
Okay.
come to the usual.
Okay. It is submitted by the Learned Counsel for the parties. That pleadings are completed. And the LCR has also been received. And therefore the matter can be listed for hearing. List the case for hearing in the usual course.
Obliged.
Obliged. Yes, ma'am.
Yes, Lordship, we'll be filing our reply to the respondents today for the state
Okay, today.
today. Your Lordship.
Okay. So when do you want it?
After 2 weeks.
MS so-and-so, the Learned Counsel for the petitioner submits that she will be filing the reply affidavit on behalf of the petitioner in the course of the day. Listed for hearing in the usual course.
Yes, Lordship.
Okay. Yes.
Your
Yes,
Lordship,
ma'am.
Can you grant us 3 weeks time to file a reply?
10 to 27. You are for, ma'am,
The petitioners.
petitioners.
Yes.
What is the case about?
Your Lordship, it is to do with a cancellation of allotment of building materials.
Cancellation of?
Allotment of building materials.
Okay. cancellation. You were allotted a building, the
they did-
materials of the building,
Yes.
and that has been cancelled by you. By
No, by the government,
on your recommendation.
yes.
On his direction. Not recommenders.
On his direction. Okay. So what is your prayer, ma'am?
Can you grant us 3 weeks time to file a reply?
Reply to whose affidavit?
Respondent 5.
Respondent. by-
We have already filed our.
Okay, okay, MS so and so. The learned counsel for the petitioner submits that she may be allowed 3 weeks time to file affidavit in reply to the affidavit in opposition filed by the respondent number 5. Prayer is allowed, listed after 3 weeks. Okay. Yes.
Right.
Yes. What is your case? Who's for the other side?
I'm for the petitioners.
Here for the petitioner and
Yes,
Mr. Vijmomi.
I'm for respondent. Respondent number 1. Lord.
Respondent number,
Respondent.
how many respondents are there?
They are 4 respondent. Lord.
What about the other respondents?
They are not here. Lord.
Represented by Gupta,
Pardon?
represented by Gupta, but I think it's not there today.
As far as the state respondent is concerned, we are just a performance.
Okay. What happened to Mr. YP Gupta?
I don't know, your lordship.
I think 24/7, 2023, there was some inadvertent mistake, correct? The order
Yes.
on the prayer of MSAIME Learned Government Advocate leaves the matter after 2 weeks. The prayer has not been objected to by the learned public prosecutor, Mr. Kiangami.
On the last occasion, Lord.
I think.
The order was inadvertent.
Anyhow,
Lord.
anyhow. YP Gupta.
My lord, my humble prayer is just to dispose this matter
Yes, disposal, yes, very simple as that, but
by causing the CR case number 1 of 2022.
by causing,
Caution CR 1 2022.
that is why you are here,
Yes.
but I have to hear the other side. The medical. 19/6/2023, I think course was imposed. Have you received the cost?
No, my lord.
No. You are not interested to receive the money.
When they are not paying, how could I receive them?
Mr. Vijmomi,
Lordship,
pay the cost.
Lordship, since I'm not in this case, my learned colleague K. Angami is appearing in this matter, Lordship.
We will make an observation that if the order dated 19/6/2023 is not complied, necessary orders will be positive.
Lordship,
Because on 19/6/2023, this court had directed the state council
Lordship,
as well as the council for the respondent number 2, 3, and 4 to pay rupees 2,000 each to
Lordship,
the petitioner.
Lordship,
We have still not paid.
Lordship, in that view of the matter, Lordship, let it come after 2 weeks, Lordship. In the meantime,
Why don't you demand? I think you are also very casual. I think you forget the orders passed by this court.
No, your lordship.
Then demand.
Lordship, the costs imposed against the government advocate may be exempted because they have nothing to do with this matter.
No, cause was, I think, cause was imposed because they were seeking repeated adjournments. That was the reason.
Lordship, as far as the instruction that I received from my colleague, Lordship, stating that the state respondent is just a pro forma respondent, Lordship, and we have nothing to do in this instant petition, Lordship.
Yes, but I think if you want to let this court do away with this order 19/6/2023, you will have to file an application for recalling the order. The order is there.
Lordship.
So without any application from your side.
Lordship.
Of course, I think if you file an application for recalling this order, I think the petitioner will be sympathetic towards you. That is what his submission reflects. Okay.
Lordship.
Mr. V. Jamoh appears on behalf of Mr. K. Angami, the learned public prosecutor, or the respondent number 1. None appears for the respondent number 2, 3, and 4. Mr. So-and-so is present on behalf of the petitioner. By the order dated 19/6/2023. This court had directed the counsel for the respondent number 2, 3, and 4, as well as the state counsel, to pay a cost of ₹2,000 each to the petitioner. Stop. It is submitted by the learned counsel for the petitioner that the counsel for the respondents have still not complied with the order dated 19/6/2023. Stop. It is made clear that if the learned counsel for the respondent number 2, 3, and 4, as well as the state respondents, fail to comply with the order passed by this court on 19/6/2023, necessary orders shall be passed against them. Kindly inform Mr. KV.
Lordship.
And if he wants at least to examine himself,
Lordship.
tell him to file a letter recalling the order insofar as he is concerned.
Lordship.
Okay. A copy of this order shall be furnished to Mr. K. Angami, the learned public prosecutor, as well as to the learned counsel, as well as to Mr. Y.P. Gupta, the learned counsel for the respondent number 2, 3, and 4. Listed on
Please.
Lordship, 31st.
3rd August,
3/1, 31st.
31st August. Listed on Okay. 31/8/2023.
Yeah, please, your lordship.
Yes, Mr. MT.
Your lordship, I am still waiting for the instruction.
What is the case about, Mr. MT?
This is regarding the battalion for eviction.
For eviction.
Yes. So I'm for the respondent number 1 and 2.
And Mr. Yamawati, you're both? Pardon?
I political matter, please.
No, you're for respondent.
Army.
Or for the. Madam, what is the case about?
Your lordship is regarding land encroachment, your lordship.
Land encroachment by the respondents.
Yes, your lordship.
In fact, it is the petitioner who has encroached our land.
This is the petitioner. Okay. So when can you file?
Up to 2 weeks.
2 weeks. Mr. M.T. Imso, the learned additional advocate general, submits that he may be allowed 2 weeks' time to file affidavit in opposition on behalf of the state respondents. Stop. Prayer is allowed, listed after 2 weeks. Any interim?
Yes, your lordship.
Stop. The interim order passed earlier shall continue till the next returnable date. Okay.
Like your lordship.
Yes, Mr. Fuseko.
Maybe Lordship.
Yes.
Lordship, I'm yet to file one affidavit.
Okay. You're for?
I'm for respondent. 4-5.
You're for respondent? 4-5.
3, 4, 5, and 6.
3, 4, 5, and 6.
Lordship, I'm yet to file 8, Lordship. I'm yet to file for respondent 8,
For respondent 8.
Lordship. Respondent 7.
Respondents. For the other respondents, Mr. Paul, you are for, okay. So you were representing respondent 4 to 8.
Respondent 3 to 8.
3 to 8, I'm sorry. 3 to 8, correct.
I'll file for respondent 3, 4, 5, 6, and 8, but I'm yet to file for
Except 7.
7. So I'm given 1 week time, Lordship.
Okay. What is the matter about? Yes,
Encroachment of land.
encroachment of, your land has been encroached. Then what about Mr. Vetro? Are you filing affidavit? It will be necessary.
No, Lordship.
Not necessary. You are the authority making the allotment. Mr. Paul?
Yes, your lordship, it is their necessary party.
Yes.
Deputy commissioner.
You are the, so far as the land is concerned, if it is a cadastral land, you are the allotting authority. So I think you will have to file. I think you have not gone through your file, I believe.
I'm yet to receive this.
I see that. Don't make a submission that you will not be filing affidavit on behalf of the government, thereby prejudicing the case of the government. Afterwards, you will be held responsible.
This is the third round of litigation before this honorable your lordship. The matter arose in 1965.
Oh,
That Lomti village, that one, that Lomti Shama has given one affidavit, SGB, that that land belongs to KL Gupta, who is the petitioner, his father. So basing upon that, they are claiming the land. In the meantime, the land was allotted in favor of, first in favor of Thongo Imlong. Then it was transferred to one lady, then it was transferred to another Sema person, then it was transferred to the present occupants who are in the land. So now basing upon that, he is claiming his ownership on the land. And actually, your lordship, that under Assam Land Revenue Regulation Act 63(3), they are filing the petition. But actually, your lordship, this is a time-barred case. Anyway, your lordship. But you had actually the petitioner had purchased the land from? No. Petitioner has not purchased any land.
Oh,
Petitioner is claiming that actually petitioner's father was serving in Army Supply Corps. It is in Army Supply Corps land, Army land. Then he is claiming that during 1965, the land was given to him by a portion of land. it was given by the army to him. And it was earlier that Lomti Shama who was and then MLA, he has given one certificate, affidavit that the land belongs to K.L. Gupta's, the petitioner's father. So, and whereas title is in our favor, and title has been continuing from person to persons, and presently in the favor of the.
I think even the army authorities, they are a necessary party. If that is what the petitioner is claiming.
Actually, Your Lordship, that land has already been transferred to this state government. And state government has already allotted.
Okay.
Allotted to in 1978 probably it was transferred to the state government. The state government has allotted to person, Thonglo Imlong, then one Sosimengla.
So what is the prayer?
Their prayer is that they came before this honorable court that the matter should be taken by the land revenue authority and not by the court. Then deputy commissioner was directed by this honorable court to dispose the matter. And deputy commissioner, after hearing both the parties, have disposed the matter, stating that if there is anything, they should approach civil court, because since it is a question of evidence is required to be adduced. So against this, they have come before this honorable court. Against the deputy commissioner. So now deputy commissioner is the necessary party who should file their how they have come to the decision that it is that the petition is not. So
I think in the petition, you have challenged the order passed by deputy commissioner.
Yes, Your Lordship.
So very much a necessary part.
Yes, yes, Your Lordship.
Mr. Paul, have you filed your affidavit?
I filed only 7 left, Your Lordship. Seven was having bereavement. His mother died, so that could not be obtained. But anyway, it is ready.
Mr. P.P. Bol. The learned counsel submits that affidavit on behalf of all the respondents from 7 to 8.
3 to
3 to 8.
3 to 6.
3 to 8, except
7.
respondent number 7 is yet to file the affidavit in opposition, and therefore 6 for 2 weeks' time to file the affidavit in opposition on behalf of the respondent number 7. Mr. Vijmomi, the learned government advocate, also 6 for 2 weeks' time to file affidavit in opposition on behalf of the respondent number 1 and 2.
Lordship, case Interim.
Prayer to file affidavit in opposition is allowed, listed after 3 weeks.
I'm yet to receive.
Yes, we are giving you time to file. Stop. The interim order passed earlier shall continue till the next returnable date. Okay.
No, please, Your Lordship.
Yes.
Your Lordship, here the pleading is completed. Your Lordship.
But the 18-7, you have filed your affidavit in reply.
Yes, Your Lordship.
Okay. Mr. Vijmomi, so can we list it for a hearing?
Lordship.
It is submitted by the learned counsel for the parties that pleadings are completed, and therefore the matter can be taken up for hearing. Listed for hearing in the usual course.
Please, Your Lordship.
Yes.
Your Lordship, here I'm yet to file counter, so kindly grant 3 weeks then.
MS Inauli, the learned government advocate. 6 for 2 weeks' time,
3 weeks, Your Lordship.
3 weeks' time to file the affidavit in opposition on behalf of the state respondents. Prayer is allowed, listed after 3 weeks.
Much obliged.
Yes, Mr. Muzi.
Lordship, I've received the affidavit in opposition filed by the state respondent, Lordship.
Yes.
So I may be given 2 weeks time, Lordship.
What is the matter about?
It pertains to the mainstreaming of the cadre, the service of the petitioners.
Mainstreaming of cadre?
Yes, so the cadre. Because they were initially appointed by way of.
RMSA?
Yes, RMSA, yes. The affidavit replies on the preparation, Lordship.
Okay.
So I may be given 3 weeks time, Lordship.
Mr. N. Muzui, the learned counsel for the petitioner submits that he may be allowed 3 weeks' time to file affidavit in reply to the affidavit in opposition filed by the state respondents.
Lordship.
Prayer is allowed, listed after 3 weeks.
Obligation.
And this Lordship,
Yes.
I've received affidavit of opposition filed by the respondent. May pray to 3 weeks to file my reply.
Reply. You want to file a reply?
Lordship, I'm representing respondent number 2 and 3. Lordship.
Reply to whose affidavit?
2 and 3.
2 and 3. Mr. So-and-so, the learned counsel for the petitioner submits that he may be allowed 2 weeks' time to file affidavit in reply to the affidavit in opposition filed by the respondent number 2 and 3. Where is the law?
Yes, Interim.
Listed after 2 weeks.
Stop.
Stop. The interim order passed earlier shall continue till the next returnable date. Okay.
Obligation.
Obliged.
Yes, Lordship. Lordship, I have instruction to appear on respondent number 3 and 4, Lordship. The medical department, Lordship.
And who is appearing for the other respondents? 3 and 4.
Yes. Lordship, this pertains to the petitioner's prayer for regularization of the service. They were appointed during the COVID time, Lordship.
3 and 4.
Yes, Lordship.
1 and 2, Mr. Vijaymomi.
Lordship, 4 weeks may be granted, Lordship.
What about Mr. Vijaymomi? Whether affidavit will be necessary for 1 and 2? 2, I think necessary.
2 will be necessary, Lordship. Because since the matter pertains to regularization,
Yes.
now 2 will be necessary. Lordship. And in fact, we have forwarded a representation of the petitioner to the respondent number 2.
Okay. You all for 3 and 4?
3 and 4, Lordship.
Mr. Vijaymomi, the learned government advocate, 6 for 3 weeks' time to file affidavit in opposition on behalf of respondent number 1 and 2. Stop. The same prayer is made by Mr. N. Muzui, the learned counsel for the respondent number 3 and 4.
Lordship.
Prayer is allowed. Listed after 3 weeks.
Obligation, Lordship.
Mr. Lordship,
Yes, ma'am.
Lordship, I'm appearing on behalf of my senior Moa Jamia. Your Lordship, here we are yet to file our affidavit in opposition.
You are appearing on behalf of
My senior Moa Jamia.
Mojamin, for respondent.
Yes, Your Lordship.
Your name is reflected in the cause list.
No, Lordship.
MS Sanso makes a mention on behalf of Mr. Jamir, the learned counsel for the respondent, for the
Sole
sole respondent. And 6 for adjournment
2 weeks.
for 2 weeks on the ground,
Some difficulties.
that the counsel leading the case has some personal difficulties. Prayer is allowed, listed after 2 weeks. Much obliged. Yes, Mr. Paul.
Yes, your lordship. My lord, this is a revision petition,
Yes.
selling the order.
Well, please give me the gist. Please give me the gist of the case.
Your lordship, the petitioners are the GBs,
Are?
GB, Western Sumi Hoho, that GB. Gaugura,
Okay.
Gaugura, Kukamis. Then your lordship, and they are the members of Western Sumi Kukami Hoho. Then Western Sumi Kukami Ho is an organization which is having their office and they are having their entity as they having their own constitution, your lordship, adopted by the members. And membership of Western Sumi Kukami Hoho are restricted to those who are the Kukamis, those who are the GBs of their respective villages. So your lordship, and the constitution of Western Kukami Hoho, it is adopted in 28(6).
Whether the government is a party
No, government is not.
and whether this court will be the right forum to take up this issue. Yes, Mr. Paul.
By way of revision, your lordship. By way of revision, I am here before this honorable court by way of revision, your lordship. The order passed by the learned PTJS. Actually, your lordship, that having agreed by the that power issued by another group, stating to be Kukamis, they have taken over the while we are selected by way of our constitution, that Article 2, that president, secretary, and treasurer are selected. And while we are functioning the office, that time, this respondents group, they have come and overpowered us. Then we compelled to approach the court of learned civil judge senior division Dimapur.
Whether proper trial was held.
No, trial has not been held, your lordship. It was in interim order. It was in interim order that learned civil judge senior division Dimapur, Nagaland, we filed one petition under order 39 rule 2, praying for restraining the defendants opposite parties to interfere from our functioning as office bearers of Western Sumi Kukami Hoho. Basing upon our petition and taking into consideration that there was a prima facie case, balance of convenience was in our favor, and we will suffer irreparable loss. And on that ground, your lordship, learned civil judge senior division has granted the injunction and allowed us to continue as office bearers of Western Sumi Kukami Hoho.
Absolute injunction?
It was
Interim.
it was no, absolute. There was hearing. Then your lordship, against this order, against the order of learned civil judge senior division Dimapur, Nagaland, these respondent defendants, opposite parties, they filed one appeal under order 43 rule 1R, read with section 104 of CPC. They filed, since this was a interlocutory matter, they filed an appeal. So in the appeal, this learned principal district and session judge Dimapur, Nagaland has reversed the order of the injunction order passed by civil judge.
On what ground?
That
On what ground?
that was reversed, stating that there was certain meeting was there, and whereby they have been what it is called allowed to continue this office by this Western Sumi Hoho. Now my prayer before this honorable court is there. I am having my, as a Western Sumi Kukami Hoho, I am having my own entity. I am having my separate entity. Though I am a Western Sumi Hoho, as a general Sumi, I am member of, I am a part and parcel of Sumi Hoho, but as a Kukami, I am having my separate institution, organization as Western Sumi Kukami Hoho. Now, your lordship, now my prayer before this honorable court, whether my constitution can be superseded by the constitution of Western Sumi Hoho. Western Sumi Hoho is a different organization. It is a of all the Western Sumi masses organization, but Western Sumi Kukami Hoho is restricted to the GBs. And we are the GBs, and we are having our separate constitution. Now, this learned principal district and session judge has conceived that constitution which was been superseded by Western Sumi Oho, and there was certain other meetings. I will come on fact, Your Lordship. Then for which the decision taken therein and the office now taken by these respondents are valid. So my very limited question is that whether my constitution can be superseded by the constitution or by the order of Western Sumi Oho. This is a very simple, what it is called.
Do you have a separate constitution?
Yes, Your Lordship. Yes.
And
Your
what
Lordship.
does your constitution say?
My-
On its appointment?
On the appointment, it says, Your Lordship, I beg to take Your Lordship that that I have given this, I was allowed by this honorable court to submit documents of the documents. And accordingly, I have submitted, Your Lordship, that big one. Now, that Your Lordship.
Your case seems very simple, but the documents does not show. I think this will have to go for a proper hearing. For the admission stage, I think, this is admission stage.
Yes, Your Lordship. Page 215, Your Lordship, my page 215 and NHR 1 at 214 from it is translated copy of my constitution. 214. Now, Your Lordship, respondent has ousted us and they have occupied our office. Should I go through, Your Lordship, constitution?
No, well, I think we'll fix for hearing.
Then a short date can be fixed, Your Lordship, because we are already been ousted from our office. And there is a.
Mr. MT, are you a member outside the constitution of the Kakami Hoho?
No. But, my lord,
Mhm.
can I just?
Yes, I just want to get the
Yes,
details.
2 minutes, my lord. My lord, there's a constitution. Yes, we subscribe, I mean, we are bound by the constitution. But, my lord, the previous president,
Previous president.
president of the
Kakami Hoho.
Kokami, term expired in 2019. 2019.
Okay.
Did not relinquish office. Tried to re-elect himself for a second term. Without his second term. So, my lord, and some for the third term. His son office first for the third term and he for the second term without relinquishing office. So, my lord objected. Information was not given to the members. So, members objected. He did not listen to, he ignored those objections. So, my lord, Kokami Hoho is a affiliated member of the Western Sumi Hoho.
No.
It is. So, my lord, therefore, under the Western Sumi Hoho, there's one particular article in the constitution which says it is dispute between selection of office bearers of the frontal organization, subordinate organizations, the advisory board can resolve the matter. So, my lord,
So whether the power to resolve also gives the power to appoint.
so now, my lord, they did not appoint directly.
Okay.
They did not do so. So they interfered and these area chairmen are members of the Kokami Ho, all these people, they were asked to send a representative from the different areas, my lord, because there are certain areas under the Kokami Ho. So those chairmen of the villages were asked to send a representative, and the representative was sent, and a nominating committee was selected, my lord. Nominating committee.
Nominating committee. Okay.
The Sumi Ho just constituted the nominating committee.
And those nominating committees are
Kokamis.
Kakamis.
Yes, ma'am. And they selected us.
Those nominating members are from the Kakami Hoho.
Yes, my lord. Yes. And they selected us. Now what happened, my lord? In spite of that, the other person, the previous president, did not relinquish office. He did not relinquish office. Now, my lord, Mr. Sumi, who again interfered, did not listen, so a reconciliation prayer meeting was held. Now, my lord, in that prayer reconciliation meeting, it was decided that Silver Jubilee is approaching in the year 2021, December 2021. So the previous president, whose tenure expired in 2019, will continue up to December 2021.
Okay.
And 14 days thereafter, after the Silver Jubilee, I will take over. My group will take over. The group selected by the nominating members will take over. Committee will take over. So we were supposed to take over on 12th of January 2022. So he continued, he accepted the terms and conditions, and based on that he continued. He continued till
There is an agreement to that effect.
yes, my lord. Agreed. He was there present, agreed, and he continued. And after enjoying everything, my lord, when his time came to relinquish, he did not relinquish. He instead appointed one executive committee, nominating committee, and selected
Who nominated the petitioner?
So there are persons belonging to that group who has enjoyed everything. After enjoying the privilege, he says, no, now I will not. He turned around. And therefore, my lord.
So the petitioners are the office bearers appointed by the
Yes, the person who enjoyed the privileges
by the committee set up by that person.
by that person. So therefore, my lord, Mr. Sumi interfered again. Sumi also accepted our thing. And now, my lord, then we came into office, but he was not relinquishing. So, but people had accepted us, so therefore he went to the court. And through this injunction order, we were ousted.
The district and session judge has passed the order in your favor.
Back again.
And you are continuing.
I'm good.
Okay, we'll hear you. The learned counsel for the parties. Pleadings are completed. Stop. Pleadings are completed.
The pleadings are complete. You will file any?
Pleadings are completed. And the matter can be listed for hearing. Listed in the hearing course. Listed for hearing in the.
My lord, early, my lord.
No, I think I have understood.
Obligement.
Let it come up in the usual course. Don't force this court to take up issues.
Obligement.
Okay. What is this, Mr. Kakri?
Lordship,
Yes, ma'am.
Your Lordship, my senior is currently engaged in court one. So if the matter may be called out after the listed matters,
Who is your senior?
Easy Momi
He is?
in court one.
No, who is your senior?
Easy Momi.
Hey, Jimmy. What is your case?
Lordship, it's about the striking of my name from the petition, from the read petition.
Striking of your name from the,
Read petition.
who has
I
struck up?
filed one IA, hearing on IA today, Lordship. I filed one IA. And that I'm asking to strike off my name from the read petition because of certain grounds.
And the respondent is objecting. Or
No,
you are the
not
counsel for the,
Lordship, they have filed one affidavit.
no, you are the counsel for the petitioner.
I'm for the petitioner.
And
Not I'm for the petitioner, I'm for the respondent, one of the private respondents. One of the private respondents.
okay,
Yes,
so you want to strike off your name
yes, Lordship,
from the case.
from the case.
And who is objecting to that?
Lordship, the petitioner, they have filed one affidavit in opposition. They say that it is more or less a case of review. So that is the only grounds they have taken. Otherwise, no any such amendment as such.
Your Lordship, my senior will be arguing this
Yes,
case.
yes, I know. Lordship, this is the case, Lordship, in short, while waiting. My regularization was challenged in earlier repetition. Then I'm not disputing that by that earlier repetition, my regularization order has been quashed and set aside, along with other private respondents who are in this case. Then see, I'm not disputing that. Then thereafter, after the pronouncement of judicial pronouncement, then since we found out that no, there was a valid records that was placed before the court. And my initial appointment, because by that earlier order passed by the in the read court, in the read proceeding earlier, the two private respondents, their appointment were upheld by this court. However, my case, my regularizations, and along with some others, that regularization has been questioned, set aside. What happened after the department, they have gone through the case? Then even my friends, those who were also part of the read petition, because they have association, so they have come to know that no, if this too has been upheld by the read court, then see your initial appointment is much earlier than this too. So the same yardstick has to be applied. So they submitted one representation to the department. Then the department they have processed. Then they have gone to the law department, PNR, then the finance department. And after that, all these clearance were obtained. And finally, that my matter was because my case was processed afresh. And finally, my case has been again reconsidered afresh. So then recently that my regularization has been reconsidered. So I'm saying that, see then now, since you are saying that the earlier, the regularizations order, which has been questioned, set aside, department has to act upon that according to that order. I'm not claiming that, the earlier one, because I'm not disputing that. My earlier regularization already questioned, set aside. I'm not claiming that. But now too, since my regularization has been reconsidered afresh, so my name be struck off from the present read process. This is my prayer, Lord.
Well, what is the case of the petitioner then? No, you are in the case.
Yes, Lord.
Awaiting Mr. Jimami.
When that the seniority list was published in the department, the names of the petitioners are come below the names of the candidates whose regularization has been questioned, set aside by the court. And still, department and by that judgment, court has, while questioning and set aside the regularizations order of all the private respondents, also directing that, yes, to go for recruitment, fresh recruitment. That was the direction. Till today, state government has not acted upon the complying to the judgment that was passed by this court. And I'm also one of the respondents there. However, my case is peculiar from the other private respondents. The veterinary associations, the employees associations, they have submitted one representations to the government that the same yardstick has to be applied in respect of me. And on the basis of that, the matter has been processed.
Yes.
The matter has been reprocessed, and finally, that my matter, that my regularization has been reconsidered afresh. That is the case.
By reconsidering your regularization afresh,
Yes.
what is the outcome?
Then now now my
Are you in service?
I'm in service.
You are in service,
Yes, Lordship.
and the petitioners are challenging your appointment.
And
Something
now-
like that.
No. Earlier, it was
I
challenged.
still haven't got you. I'm sorry, but
Lordship, all of us, we were in a contract service initially. Then subsequently, all of our
You-
contract service have been regularized. Petitioners, they came to challenge our regularization order. Then finally, this honorable court question set aside all our.
Regularization order. Okay, to that extent I have understood. Then,
Yes, Lordship.
then,
Then, while questioning our regularization order, court also has directed the state respondent to go for recruitment against the posts that are vacant in the department.
in which you were appointed.
Exactly, Lordship. State government has not acted upon it.
Okay,
Yes, till today, can see.
no advertisement till today. That's
Till today. But in the process, again, the veterinary association, my association, they have submitted one representation to the state government, saying that no, in the writ proceeding, though question some of the regularization orders of some private respondent, whereas two respondents, the regularizations of two appointees, that was upheld. The regularization order has been upheld by this court. On the basis of,
respondents in that case.
because see, they have completed 10 years by that time. So on the basis of that, the judgment of Uma Devi's case. So this two have been left out. And all the remaining regularization order has been quashed and set aside. Then after seeing that, the associations that have submitted the representations, because see, I was also completed more than 10 years by that time. However, my initial appointment order has not been protected and brought to the notice of the court.
Okay.
Yes. So in that regards, they have submitted one representation to state government to reconsider my case and to apply the same yardstick as that was upheld by this court. So that was gone to the law department, then PNR, then after concurrence of the finance department, cabinet has cleared my case. And my regularization order has been reconsidered afresh. So I'm bringing this, I'm before this court to quash and set aside, to strike off my name, to drop my name from the present writ proceedings.
That is your case.
That is my case.
What about the case of the petitioner?
Your lordship, we're coming to this court to ask for quashing and setting aside of the seniority list dated 1/7/20.
No. If the case of the petitioner is to quash and set aside the seniority list, then I think this court will decide the case on merit. Yes. So I think at this stage, your petition may not be entertained.
Yes, if then unless again, the petition is amended.
Because here the petitioners are actually like questioning the challenge seniority.
Seniority,
Correct.
lordship,
And you are being placed above them.
lordship.
Exactly. That's so I think we will have to decide the merit of the case.
Yes, lordship. So
So your petition for striking of your name from the case will not survive at this stage.
lordship, that may be heard. That may be heard.
Yes, we will hear you, but I think from the gist you have submitted, since the dispute relates to seniority,
Yes,
and since the petitioners are disputing your seniority,
lordship.
I think the merit has to be heard.
So lordship, that may be heard. That may be heard.
Yes, when can we hear it?
Today,
The case, not today. Hear the case, entire case, not the petition, not the petition.
well, then my IA may be disposed of. My IA, lordship, I filed one IA.
What is your IA?
Lordship, IA 43. 43 of 2023.
Mr.
Your lordship, here I'm appearing for respondent
Okay, let us.
6/15.
Mr. Kringuli, the learned counsel for the petitioner, applicant. Stop. The IA filed by the applicant shall be heard along with the main application. Application disposed. Okay. Yes, listed on, the main case is listed when?
Your lordship, there is another IA, your lordship.
No, IA it's also listed today, lordship, along with the IA.
Okay. So what is the next IA?
Lordship, it's IA 191.
What is that IA for?
Lordship, regarding non-maintainability of the writ petition, your lordship.
Regarding non-maintainability of the writ petition.
Your lordship. Filed by respondent number 6/15, your lordship.
What is your case? What is your case?
Lordship, we're praying that Lordship would come to page number 3, Your Lordship, page number 5, Lordship.
Which is
The
IA
I-181, Your Lordship.
191.
Lordship, our main environment is that, Your Lordship, the humble respondents were appointed during 2005 to 2018, Your Lordship, in the sanctioned vacant post for the veterinary.
And what is your IA for?
Lordship, for non-maintainability, Your Lordship. Under,
For against maintainability.
yes, Your Lordship, under order 7 to 11 of the CPC, Your Lordship.
IA 191, okay. Heard Mr. M. Solo,
Your Lordship.
learned counsel for the applicant. The IA one, the present IA, which is filed on the maintainability of the writ petition number 168/2022 shall be heard along with the main writ petition. In the main writ petition, listed after 3 weeks. Okay.
Your Lordship, I beg for your indulgence in item number 10 to 27. This is an interim. Can you extend the same?
10 to 27, the interim order passed earlier shall continue till the next returnable date. Okay.
Much obliged.
Obliged. For orders, item 16.
The 2014 is for the petitioner. This is which item? 60. 60. Four 2017. Listed after the pronouncement of judgment by the Supreme Court. The status of the matter is listed for further appropriate order. Further appropriate order. 25. The 30. In view of the notice, the listening is directly this is pending within a period of 4 weeks from today. Okay. None appears. By the order dated 35/20/23, the petitioner was directed to furnish the details of the case, which is pending before the Honorable Supreme Court within a period of 4 weeks from today. So neither the details as directed by the order dated 35/20/23 is placed before this court, nor is the petitioner represented. Listed after 3 weeks. So the petitioner is also directed to comply with the order dated 35/20/23 passed by this court.
Next, Lordship.
Yes.
Lordship, this on the court by order dated 5/6/2023 directed the appellant to take steps.
5/6.
In Q3.
Yes.
Q3. I've directed the appellant to take steps on the for service of notice upon Respondent 2 and 3.
Yes.
Lordship, the appellant has complied with this honorable court's order.
Yes.
And Lordship, filed an affidavit to that fact, Lordship. I filed on 25th of this last month. The affidavit is annexed with the annexure paper of application made in Assam on 15th June.
This Assam Tribune.
Assam Tribune, Lordship, on 15th June. Lordship, may find the relevant portion at page number 2.
This two and three.
2 and 3, Lordship.
Who are the 2 and 3?
Lordship, 2 and 3 are the owner and the vehicle driver. Owner of the vehicle and the driver of the vehicle.
By the order dated 5/6/2023. The learned counsel for the appellate was directed to take steps for service of notice upon the respondent number 2 and 3 by paper publication, which is widely circulated in the place where the respondent number 2 and 3 resides. Stop. The appellant has accordingly complied with the order dated 5/6/2023 and has filed the affidavit dated 26/7/2023, stating publication of the notice. The notice upon respondent number 2 and 3 is therefore deemed complete. Then what next?
Lordship, may I please your lordship,
Yes.
for the respondent number 1.
Okay,
Lordship, since the pleading is completed, LCR may be called for in lordship.
Yes, Lordship, LCR. No, LCR, since
yeah, received. It is
Lordship, the matter can be posted
Posted
in
for
the
hearing.
hearing in the usual course.
that the matter be listed for hearing in the usual course. Okay,
Highly obliged.
Oblige, lordship.
yes, ma'am.
May I please, Lordship, last Friday, Jayanmuli has told me that he will be representing respondent number 2 more.
He has not told the court. He has told you.
Yes, and he
He has
asked me
not-
to serve a copy to him. And today he didn't come.
Union of India is a party.
Yes, Lordship, respondent number 2.
Then Zatanmuli is for Union of India.
Yes, Lordship.
What is the case about?
Here the petitioner is seeking for compensation for property damage.
Yes, ma'am, in only any affidavit to be filed.
Your Lordship, on behalf of VGMO, Your Lordship, he has yet to receive instructions, so kindly grant 3 weeks time, Your Lordship.
Three, four, five. 3, 4, 5.
Yes, Your Lordship.
Who is for 6?
Lordship, I'm for 6.
You have filed your affidavit.
Yes, your lordship.
Who is for 7? NHI? You file your affidavit?
Yes, your lordship.
Okay. MS. So, the learned counsel for the petitioner submits that she has served a copy of the writ petition to Mr. Zatan Muli, CGC, who is representing the respondent number 2. Stop. You are actually mentioning on behalf of
VGMO, Your Lordship.
MS Inauli. Makes a mention on behalf of Mr. V. Jimomi, the Leonard government advocate, and 6 for 3 weeks' time to file affidavit in opposition on behalf of respondent number 3, 4, 5, 3, 4, and 5. Stop. The respondent number 6 and 7 have filed their affidavit. 3 weeks' time is granted to the respondent number 2, as well as the respondent number, state respondent number 3, 4, and 5 to file their affidavit.
Much obliged.
Listed after 3 weeks.
Rashmani.
Please excuse me for 2 minutes.
Yes, Your Lordship,
Yes,
I beg for indulgence in item number 9. There's
item
an-
9.
Yes, Your Lordship, there's an interim. It may be
Item
not-
9. The interim order passed earlier shall continue till the next returnable date. I think that is most important for you. Instead of making other submission,
Lordship.
you should first submit first submit to extend the interim order. So that you.
May I please?
I'm appearing for respondent number 5. I'm appearing for respondent number 5. Your Honor, I filed my bakalat nama this morning only. So I pray that
Mr. M. Solo,
Your Lordship.
this notice was for respondent 5.
Yes, Your Lordship, was for respondent.
Good. Okay, okay. Have you filed your wakalat nama, ma'am?
yes, Your Honor. I felt this morning only.
Okay.
I felt this morning. So I
So-
agree to file affidavit for 3 weeks, Your Honor.
Yes, what about
Same prayer for the state, Your Lordship.
the learned government advocate? As well as MS so the learned counsel for the respondent number 5. 6 for 3 weeks' time to file the respective affidavit. Where is allowed, listed after 3 weeks. Yes, ma'am.
Please, Your Lordship. Lordship, service notice upon respondent number 4 is completed.
Service.
And to that effect, we have filed our affidavit.
Who is respondent number 4?
The Yangzitong Village Council.
When did you file your affidavit?
On 19/6/23.
Yes.
Yes,
MS,
your lordship, I'm appearing on behalf of respondent number 1, 2, and 3, your lordship. So I'm yet to file counter in this matter. So kindly grant me 3 weeks time, your lordship.
by the order dated 18/4/2023. Notice was directed to be served upon the respondent number 4 through Dasti process and to file affidavit to that effect. The petitioner has accordingly taken steps and has filed the affidavit dated 19/6/2023, stating service of notice by Dasti process on the respondent number 4. Stop. The notice upon respondent number 4 is therefore deemed complete. MS Inauli, the learned government advocate, 6 for 3 weeks time to file affidavit in opposition on behalf of the state respondents. Prayer is allowed, listed after 3 weeks.
Much obliged.
May it please your lordship.
Yes.
Lordship, state may be granted a further time of 4 weeks, your lordship. I'm making a prayer on behalf of A.T. Bapom.
Okay. The learned government advocate, 6 for 3 weeks time to file affidavit in opposition on behalf of the state respondents. Prayer is stop. Prayer is allowed, listed accordingly.
Worship, there's an interim.
The interim order passed earlier shall continue till the next returnable date. Okay.
Your lordship, I'm praying on behalf of AIME, your lordship. She's yet to file, so kindly grant 3 weeks time to file
AIME.
counter. Yes, your lordship.
The learned government advocate, 6 for 3 weeks time to file affidavit in opposition on behalf of the state respondents. Prayer is allowed, listed after 3 weeks.
Lordship,
obliged.
if I may, lordship,
Yes, please.
service notice for respondent number 4 still awaited. Lordship, in that matter, allow me to serve again by way of Dasti to the respondent number 4. By the respondent.
The learned counsel for the respondent number, the learned counsel for the petitioner is allowed to serve notice upon respondent number 4 by Dasti process within a period of
3 days.
within a period of 3 days from today, and to file affidavit to that effect. Listed after 3 weeks.
Lordship, there's an interim.
The interim order passed earlier shall continue till the next returnable date. Okay.
Much obliged.
Wait, this lordship.
Yes, Mr.
Lordship.
MP, what is the matter?
Lordship is seniority.
Seniority.
Yes. And
You are the petitioner.
I'm the petitioner. 100% people who have been appointed illegally has been made
Senior.
in the tentative seniority list, and which they want to treat it as the final list because promotions were about to be made based on the seniority, tentative seniority list.
Okay.
So we approached my lord, and this honorable court has given us protection, saying that till the final seniority list is finalized, till the final seniority list is finalized, no promotion should be made to the order that is 7/6/23.
Okay. So, ma'am, what is?
I'm praying on behalf of K. Angami, your lordship. He's yet to file counter, so 3 weeks time.
When this court has passed this kind of interim order, I think you should expedite in filing your affidavit.
Yes, your lordship.
Because you have not come for vacating modification of this order. So I think that the only course is to expedite the affidavit.
Yes, your lordship.
Okay, tell Mr.
K. Angami.
Kiangami. And yes,
Time for respondent 4 and 5.
have you filed your affidavit?
No, lordship. So kindly grant me 3 weeks time to file.
4 or 5, okay. And what about you?
Lordship, I'm for respondent number 6, 7, 8, and on behalf of Supamati, respondent number 9.
6, 7, 8.
9.
You 6, 7, 8 and 9.
Yes. Kindly grant me 3 weeks time to file my affidavit. Lord.
Okay, okay. Mr.
Lordship, I just.
Yes, please.
Lordship was very gracious to say not by a promotion till the seniority list is finalized. But on the next date, my lord, inadvertently, we made a prayer for extension of the interim.
It's all right.
So therefore extended till until further order, till today only. So therefore, my lord, in terms of order date is 7/6/2023.
7/6/2023.
Yes. So interim to continue in terms of 7/6/2023.
MS. Inaholi. On behalf of Mr. K. Angami, the Learned Senior Government Advocate. 4 and 5, who?
The blue
Mr.
marshal lordship. The blue
Mr.
The blue marshal.
So and so. Learned Counsel for the respondent number 4 and 5. And Mr.
Our senior lordship.
So and so, the Learned Counsel for the respondent number 6, 7, 8, and 9. 6 for 3 weeks' time to file their respective affidavit in opposition. Prayer is allowed. 3 weeks' time is granted to the respondents to file their affidavit in opposition. Stop. The interim order dated 7/6/2023. No. The interim order shall continue as per the order dated 7/6/2023. Okay, listed after 3 weeks.
Much.
Yes.
Your lordship, I beg for indulgence in item number
Yeah, no.
59. Your lordship, there's an interim,
59.
yes, there's an interim in the main petition. Kindly
59.
extend the same.
The interim order passed earlier shall continue till the next returnable date.
Much obliged.
This is item 70. Yes, Likase, what is your case?
My lord, this is for regularization in service, my lord.
Regularization in service.
Yes, my lord.
Does this court has the power? Whether this court has the power to regularize you?
My lord, I'm seeking in terms of the employees who have been regularized. They are senior, junior to me, my lord. And now my case here is that, my lord, I have been appointed as fixed pay typist, my lord, under the establishment of commissioner, deputy commissioner.
What charge?
No, my lord, contingency, on contingency, fixed pay, my lord. Fixed pay of rupees 450. And now I'm receiving 6,000 per month, my lord. Initially, I was paid rupees 450 per month, and now I'm receiving 6,000, my lord.
450.
Yes, my lord. And I've been appointed on contingency, my lord. My
Now
lord,
you are receiving
now
receiving
6,000, my lord.
6,000
Yes, ma'am.
presently.
My lord, before I begin my submission, I would like to take your lordship to order dated
Yes, what it
39/2022, my lord.
is it a part of your annexures?
No, my lord. We are here, respondent number 4 to 15 has been made as performer respondent. However, this court has passed an order that without, it will not have any effect to the performer respondent number 4 to 15 if any order is passed by this honorable court, my lord. That's, may I read, my lord?
Oh, yes.
Order dated 39/2022. Affidavit of the respondent numbers 1, 2, 3 have been filed. However,
notice issued to Kohima, respondent number 4 to 15 are yet to return. Mr. Nikasi Sangam, learned counsel appearing for the petitioner, submits that the matter can be taken up for hearing since the affidavit of the main respondent has been filed. And as in any case, the rights of respondent number 4 to 15, who are performer respondents, would not be affected. Ms. Lucy Leonard, senior counsel, government advocates appear on behalf of the state respondent, considering the submission of the learned counsel of the petitioner and the facts and circumstances of the case. This court is of the view that this case can be listed for admission hearing.
Okay.
Yes.
Okay.
So here, my lord, Annexure A is my appointment order. my lord.
Okay, that just before going to the records, just give me the gist.
My lord, there, I was appointed as fixed pay on contingency, fixed pay of rupees 450.
When?
On, I was appointed on 30 May 1998, my lord. With effect from 1/9/1998, my lord. Now, my lord, while serving as typist, the state government has done away with the post of typist, my lord. And now the employees who have been working on fixed, they have been regularized on phase wise. And there. Yes, my lord. And now here, my lord, in whilst working as typist, the state government has done away with all the typist posts. And those who are serving, they were regularized on phase wise. And there one instance is that I was appointed in the year 1998, and the employees who were junior to me, that is who were appointed after me, they were regularized me, leaving behind me, my lord. Here, those persons who were regularized, they were serving under Nagaland Civil Secretariat. However,
Regularized. Who were regularized were serving under Nagaland Civil Secretariat. And you are serving under?
Nagaland House, Gauhati, my lord.
That is what? Is it the directorate or?
My lord, that comes under Home Department, controlled by the Home Department.
But you are not an employee of Civil Secretariat.
Controlled by Home Department, my lord. My posting and transfer
That's
is,
why I want to clear myself, whether you are an employee of the Civil Secretariat.
my lord, actually in
Ms.
all
Maria,
categories, in
yes,
category,
kindly
all
satisfy
categories,
this
my
one.
lord.
Actually, the appointment itself, the nature of the appointment is contingency, your lordship.
Contingency.
There is no vacant or sanctioned post, your lordship.
And
So
what was the nature of appointment of those persons who were regularized in the Nagaland Civil Secretariat? Nagaland Civil Secretariat.
Secretary, they have the rules governing that. Whereas here, actually here in this repetition, the petitioner has misconceived, your lordship. He contended that there are 81 who has been regularized.
There?
And 81 person who has been regularized, and some of them are junior to him. But then that comes to from another, he is from different cadre. The petitioner is from the GAB, from different branch, your lordship, though they are under Home Department, your lordship. So
And the others are from SAB.
SAB 2.
And petitioner is from GAB.
GAB 2. So
Well, what is SAB's?
Secretariat Administrative Branch, your lordship.
And GAB General Administrative.
General Administrative Branch. your
General
lordship.
Secretary. Okay.
Yes.
Okay. Okay, continue. Okay, thank you.
So, my lord, though the person who were regularized were put under SAB and I'm put under JB, but it's all under the ambit of Home Commissioner, my lord. So, for instance, like in establishment, there are different branches. So, in order to look up or for the convenience of the employees, it's put under different branches. So, in my case also, though I'm employed by the Home Commissioner, but I've been posted at Nagaland House, Gauhati. So that's how I'm put on under different branch, my lord.
That means all of you, those who were regularized and those who were not regularized, including you were appointed the rules. Correct. You were appointed without advertisement, without following the due process of law. Correct.
Yes.
Correct.
Yes, that's true.
Now you tell this court, how can this court extend the principle of negative equality to you? You tell me. If you can say that the others were illegally appointed and therefore I also have the same right, I will appoint you. But if the other's appointment is illegal or irregular, you cannot claim the benefit of that right.
No, my lord. I've been appointed under what the Naglinaw squad.
That I know.
Yes. So, see, my lord, I'll take your lordship to one of the annexure, my lord.
I hope you are not forcing this court to commit the same mistake.
No, my lord. My lord, what I want is that I'm real Lord annexure where the state respondent has passed an order to regularize the person who are similarly situated.
That's why,
and my lord,
that's why I'm saying, just because you are similarly situated, whether this court can extend you the same benefit which is illegal. You satisfy this court on that, because actually I think your case revolves on Article 14, negative equality. So you satisfy that the relief which was the benefit which was given to the other persons who were regularized.
Yes.
Were legal. You tell me that.
My lord, in that case, may I pray before your lordship to come up next week?
You take a chance. If
Yes,
not, I am not very.
Yes.
You take the chance.
Yes.
Okay, Miss Mary, we give him 1 more week's chance. If
my lord,
you come prepared on that ground.
Yes, my lord. Yes.
I have told you, I have given you the clue.
Yes.
If suppose the others are illegally or irregularly appointed, you have a right to claim the same benefit. You come with that.
Yes.
Positive answer.
My lord, in that case, can it be after 2 weeks? 2
Yes,
weeks.
you can take your time. You can take your time. Mr. Likhasi, the learned counsel for the petitioner. 6 adjournment for 2 weeks. Listed again after 2 weeks. Okay. Come. Yes, Mr. Likhasi, this is also your case?
Yes, my lord.
76.
Yes, my lord.
What is the case about?
My lord, here the petitioner husband was serving as office peon under this establishment of respondent number 3, my lord. And while serving as office peon, he was on leave. He was on leave and he went to his native village. And while on his journey to his home village, native home, he went missing.
He went missing?
Yes, my lord. And the state respondent has issued calling notice to report to the office within 15 days. However, the petitioner husband could not report to the office to the calling notice issued by the state respondent. And thereafter, the service of the petitioner husband was terminated, my lord.
Where is the husband now?
Not aware of his whereabouts. Still.
The husband is still missing?
Yes, my.
And what petition have you filed? What is your petition?
Seeking for the termination, to quash and say that aside the termination order of the.
I don't know whether actually you will have a right.
And to grant pensioner, family pensions to the petitioner money.
Have you ever in your petition that your husband has died? Have you ever in your petition that your husband is no more?
My lord, as per Indian Evidence Act, section 108 of Indian Evidence Act, if a person is
7 years.
Yes,
And who is to give that declaration? Who is to give that declaration? You cannot just say that since the law provides that 7 years missing, a person is presumed to be dead.
yes,
He's dead. You're gonna, I think there is some procedure, there is some process
yes, my lord.
to declare you that person as dead.
Yes, my lord.
Who is that authority?
The civil court.
Have you approached the civil court?
I've
Then?
not,
You were jumping over the fence and coming.
my lord, here rightly or wrongly, the
No, don't make that submission rightly or wrongly. Always right. You are always right. As a petitioner, you are right.
yes, my lord. Yes.
So what to do? You have not taken recourse to that.
My lord, actually here I've annexed one declaration, my lord, which was which is registered before the CJM, Chief Judicial Magistrate, my lord. That declaration. And he has authenticated declaration. So
Just let me see that.
page 31, my lord.
Page 31.
Yes. Annexure J, my lord.
Page. Page 31.
Annexure J, my lord. Yes. Merit, my lord.
No. This is a declaration by you. This is a declaration by you,
Yes, my lord.
which is signed by the magistrate.
Yes.
So whether that will be the correct process
And here,
to declare your husband is dead because he's missing for 7 years.
and there the magistrate is registered.
It's all right that those things is registered, signed, okay, but whether
Because of this,
just by giving a declaration. What does the law says about that 7 year? Presumption of date.
my lord,
What does the law says?
I would like to rely on one citation, my lord.
No, what does the law says? Let us come to citation afterwards. What does the law says? 7 years missing,
Yes, my,
presumed to be dead.
yes, my lord.
So what is actually the recourse to be taken to declare him dead because he is missing for 7 years? What is the procedure?
Here, my lord, the only ground is
The law.
to approach the civil court.
Have you approached that? Have you approached the civil court?
No.
Let us see the provision. Which is the provision
Once, section 108.
of CPC?
Indian Evidence.
Indian evidence, let's see. I think this, you will have to do proper homework and come. Which section?
108, my lord.
108.
Yes, ma'am.
Burden of proving that the person is alive who has not been hurt, or burden of proving that the person is alive who has not been hurt after 7 years. The question is whether a man is alive or dead, and it is proved that he has not been hurt for the 7 years by those who would naturally have hurt him. The burden of proving that he is alive. No, Mr. I think this is not the correct section. The presumption as to death by reference to section 1 and would not by applying any logic or reasoning. An occasion for raising the presumption only when the question is raised. An occasion for raising the presumption would rise only when the question is raised in the court. An occasion for raising the presumption would rise only when the question is court, tribunal, or before an authority who is called upon to decide as to whether a person is alive. So long as the dispute is not raised before any forum, and I think it's premature.
My lord, here my case is that right immediately after the missing of my husband, I guess.
We are not on whether your husband is missing for 7 years or not.
Yes,
We are on the question, what is the procedure to be adopted by you to declare your husband dead if he is missing for 7 years? What is the right recourse you have to take?
yes,
And actually, it says that unless, so long as the dispute is not raised before any forum in any legal proceeding, the occasion for raising the presumption does not arise. So I think you will first have to take this step. You see, this is given in EIR 2004 SC 2070. What is your citation?
GLD 429.
What is it?
My lord, there it says. Matter petitioning. My lord, it's a short citation.
No, you just read the relevant.
In view of the above, this court would presume that the aforesaid Sri Ram Prasad Verma is no more alive, as he has not been heard for more than 7 years by the petitioner and the family members. As such, the responding authorities can act upon the said police report for the purpose of grant of family pension in favor of the petitioner. Accordingly, the responding authority, more particularly the respondent number 2 and 3, shall do the needful for issuance of the final report as regard the factum of the missing of the aforesaid Sri so and so for more than 7 years for the purpose of grant of family pension and be issued to the petitioner without any further delay. Preferably within a period of 1 month from the date of receipt of a certified copy of this order. After the petitioner would approach the appropriate authority along with the said final report and other required documents for grant of family pension in her favor. It is also made clear that upon receipt of final report and document as may be furnished by the petitioner to the competent authority, the competent authority will finalize the payment of family pension to the petitioner within a further period of 2 months from the date of receipt of final report as well as required documents as directed and government.
No law has been laid down.
Yes.
That is only discussing the facts.
Yes. My lord, here my prayer is.
What's your husband in regular service?
Yes, my lord. My lord, here my prayer is very limited. Here, what happened was that immediately I lodged a complaint to the police station. However, till now, the police station, police station railway thana has not issued any report. So my only prayer is to give direction to the respondent number 4 and 5 to give direction about the report which have made a complaint. That is only my prayer before the before this honorable board and to quash and set aside the termination order. My lord, here, even if I approach the appropriate forum, unless the report is given by the Thana, it will be difficult for me to approach the appropriate forum also, my lord. So I'm
No,
before this.
the appropriate forum, that is actually the civil court or the right forum.
Yes.
Can always act on your application which is given to the police. You let us hear it again. I think next Monday. But you go through this, ruling of the Supreme Court. AIR 2004 SC 2070. AIR 2004 SC 2070. Because here it says that so long as the dispute is not raised before any forum and in any legal proceedings, the occasion for raising any presumption does not arise. That is what this book says. So let us, I think, approach your case quite very cautiously.
Yes,
Because actually just blindly issuing directions will not do. Let us also know what is the law.
yes, my lord. And
Ms. Mary,
my lord,
please assist the court on this. Okay, we'll list it on Monday.
my lord, on 26/20/23, this board has also observed that Home Commissioner is also need to be made a party in the instant case.
Home Commissioner.
So, yes.
What was the reason? What is the reason?
Marry the order.
Yes,
my
please,
lord.
yes, please, please.
Order dated 26/20/23. Heard Mr. So-and-so learned counsel for the petitioner as well as Mr. So-and-so learned government advocate Nagaland appearing for the state respondent 1, 2, and 3. Mr. So-and-so learned government advocate appearing for the state respondent so-and-so submits that as the whereabouts of the petitioner suspect who went missing at Patna railway station is not known since the year 2013. Home Commissioner to the government of Nagaland is a necessary party for just disposal of the instant petition as he is responsible to ensure proper protection of the local people of the state. And in the matter in hand, the Commissioner Home can contact the competent authority of Bihar to make some breakthrough in the matter. In view of the above, the petitioner shall include the Home Commissioner to the government of Nagaland as respondent number 6 by way of filing amended.
Whether you have completed?
Yes, my lord.
You have
Notice has been served.
Notice has been served. Miss, Madam, you are representing? Another issue arises again after reading that. The person went missing from Patna.
Yes.
I think you will have to do quite a lot of homework. If the person went missing from Patna, whether the issue arises is whether this court will also have the competence to take up this case, or whether it will be the court at Patna.
My lord, the petitioner is the resident of Nagaland and also.
No, so far as the missing portion is concerned. So far as the missing portion is. I think you will have to address the court on all this. Not just that your husband went missing for during the last 7 years and therefore he is presumed to be dead and therefore the order passed by the department like removing his name from service should be strike off and then he should be entitled to pensionary benefits. It's not simple as that. It's not simple. I think there are so many nitty-gritties of this case. Kindly come well prepared to address this court on all these issues. Ms. Mary, I think you will also have to do a lot of homework. Please. Okay. List the case again on 21. Monday.
Can it be on Friday, madam?
On?
Friday.
Not Friday. This coming Friday.
Okay. This coming.
Not this coming Friday. Let it be on 21.
Okay.
Come prepared.
Yes.
Don't just come very casually. Come prepared. Listed again on 21/8/2023. Okay.
Yes.
You come prepared. Because I think there are some issues which we have to properly deal with.
Yes. Okay.
What is this, Mr. PB Paul?
This is pertaining to on probate case, Your Worship.
Yeah.
But this is an appeal whereby the probate has been allowed by the learned trial court in favor of the respondent. That's if your lordship may kindly permit me.
So you have not contested the probate case.
But sir, I was not even informed in spite of the pendency of a suit at Seeker Court, where she was served and interim order was operating without making any notice of the pendency of these proceedings in any of the proceedings pending in Seeker Court. The probate has been.
In which court?
In Seeker Court, district Rajasthan, state of Rajasthan.
Sita.
Seeker. Seeker is a place, my lord, district Rajasthan, state Rajasthan. Both the properties are in state of Rajasthan, district Seeker. One property is in Jaipur, that is again in Rajasthan. In regard to that properties, a will was at least to be prepared by the respondent in Nagaland. And the probate proceedings were initiated without issuance of citation, without following the mandatory provision provided under the Act of Indian Succession Act. And I can demonstrate before your lordship that in what manner mechanically formed the trial court has issued the probate. Your lordship will give me some time, I can make my submissions. Some of the dates would be relevant for the purpose of deciding this case. The alleged will is dated 21/10/2019. The registration of the will is stated to be on the next day, that is on 23rd/10/2019. And the executant died on 24/10/2019. That is Kesri Devi.
Which are you?
Kesri Devi, the executant of the will.
Her
name was Kesri Devi.
The person who executed the will. Kesri Devi.
Kesri. Now the will, Ali's will is to be executed, has been shown to be executed on 21/10/19, registration on 23/10/19, and death on 24/10/19. Properties in respect to which this will is made.
The executant has expired.
Has expired on 24/10/2019.
When was the will made? Will made?
Beg your pardon?
When was the will made? Will made on
2019.
21/10/2019. 2019.
Registered on 23/10/2019.
Registered on 23/10/2019.
And the testator, that is
testator,
died on 24/10/2019.
Died on
24/10/2019.
24/10/2019.
The next very day of the registration. This is undisputed. Probate proceedings came to be filed on 7/10/2020. By the executant,
probate proceedings
by executant of the will that was named
filed on
7/10/2020.
7/10/2020. 2020. By the
executant named as Pradeep Jhancheria.
By the executant. What was the name of the executant?
Pradeep Jhancheria.
Pradeep?
Pradeep Jhancheria.
Pradeep?
Jhancheria. JHAN.
JHAN.
JHARI.
JHAN.
RI. JHAN. JHARI. Jhancheria. And in brackets it is shown as Jain. 3 properties were shown under the will, and all 3 properties are situated in the state of Rajasthan.
Where is that property? Where is that?
All 3 properties are in
Where
the
is
form
that?
of land. Your lordship may see the will. The will.
Where is that will?
Your lordship will find the will at Annexure 4, page 42 of the paper.
Page
42 minutes.
paper book.
There is no paper book, your lordship. It is their petition.
It is petition. I am calling paper book as my memo of appeal. We call it as a paper book over there. The memo of appeal can be seen. Page 42 of the memo of appeal.
Excuse me.
The details of the property are at page 45. Details, my lords, will find at internal page 4, external page of the memo of appeal at page 45. Roman 1. I hereby.
Just wait.
Beg your pardon. Page 45.
This is will dated 21/10/2019.
19. Have you not got page 45? The details of the property.
I am having loans son and the particulars of my family member.
He has mentioned the particulars of the family. Amarnath Sethi is his adopted son.
And who is the appellant?
The appellant is the son of deceased brother. And was having 2 registered will in his favor, executed at Seeker by the deceased in respect to 2 properties which were situated in Seeker. He is the appellant before you. I have annexed those will also before your lordship in the with the appeal. May I read the?
Just wait. Let me first understand.
I'm sorry.
Whether all the properties mentioned in the will stands in the name of the executant.
Yes, that is not it.
Yes.
So there is no dispute on that.
Testator is owner of the property.
So who are the beneficiaries of this will?
The wife of Amarchand. That is the daughter-in-law
Daughter-in-law.
of deceased.
Amar Chand.
Amar Chand is
Amar Chand is the testator's adopted son, adopted son.
Your Lordship, she was issueless. So that Bhajanlal
Yeah,
Sethi-
that we will come, but so the beneficiary is Manju Devi Sethi.
yes, daughter-in-law. The appellant is not anyway the family member of Kesari Devi.
So all the properties mentioned in serial number 1, 2, 3, 4. 1, 2, 3,
is movable property.
1, 2, 3, 4.
4.
No, 1, 2, 3. 1, 2, 3. Serial number 1. These are all immovable properties.
These are immovable
1, 2, 3.
situated in the state of Rajasthan.
Just wait.
Right.
1, 2, 3. So this property 1, 2, and 3. This was bequeathed to her son and her daughter-in-law, Manju Devi. Two residential, okay. Who has filed the probate?
The probate was filed by the executant of the will, that is Pradeep Jhanjevi.
And what does the probate court says? Let us see.
Probate court has not only said one thing, without seeing the nature of the case, only one thing, that there is no objection by any party, therefore it is allowed. Where could be the
Any
objection?
notice issued, Mr. Paul?
Yes, Your Lordship. The list.
I'll just.
Okay.
No,
I'll just.
Let us come to the order. Let us come to the order.
This order, your lordship will find as annexure 1, page 22 to 26.
Annexure
1,
page
22 to 26.
22 to
26.
22, okay.
The order date is 2nd of March 2021.
22 page Let us see the operative
If
portion.
your lordship may kindly permit, before coming to the order,
Hmm.
the probate petition is very necessary to be seen by my lords.
Okay. No,
Because
I will come to that, but let us see what is the finding.
From
of
your
it.
lordship, as your
Welcome.
lordship, I am in your lordship's hand. This is an application under section 276 of the Indian Succession Act 1925, praying for probate of the will dated 21/10/2019 of late Srimati Kesri Devi Sethi, wife of late Bhajan Lal. Heard submission of the learned counsel, Hitoka for the petitioner. The case of the petitioner in brief is that he is the executor of the will, whom the late Shri Kesri Devi Sethi, wife of late Bhajan Lal Sethi, had appointed while the last will was executed. And after registration of the will by the sub-registrar Dimapur, Nagaland, by registration number 69 dated 23/10/2019, and the same be kept under the custody of the petitioner. It is submitted that the will was duly executed by the testator late Srimati Kesri Devi Sethi, wife of late Bhajan Lal Sethi, in the presence of witnesses as named in the said will. It is further submitted that the said testator died on 24/10/2019 at house number 65 GS Road, Dimapur, Nagaland, at the residence of Amarchand Sethi, and the petitioner is the executor named in the last will and testament of the testator late Srimati Kesri Devi Sethi, wife of late Bhajan Lal Sethi. That the said testator had fixed place of abode at house number 65 GS Road, Dimapur, Nagaland, under the care of Amarchand Sethi and daughter-in-law Srimati Manju Sethi. That the said testator had left behind the following landed property. May I read these three?
Yes, please.
Commercial land at Shastri Nagar, ward number 15, Old, on the main road of Ashok Vihar to Rani Sati Road, Tehsil Sikar, district Rajasthan, with particulars as stated in the will. 2 residential plots of land measuring 13,860 square feet is situated at Sethi Colony near Bara Talab, Sanwali Road, Sikar, with residential building named Adinath Vihar, Rajasthan, with particulars as stated in the will. Plot of land at Vardhman Nagar, zone number VB, Jaipur, Rajasthan, revised plot number 290A and 291A, measuring 4,500 square feet, with particulars as stated in the will. Movable properties consisting of bank accounts, lockers, cash, share as partner of Messrs. Dimapur Provision Store, GS Road, Dimapur, Nagaland, and income tax filed PAN number ANPS 7057G. The properties at para number 6(1) and Roman 2 are situated within the territorial jurisdiction of District Judge Sikar, Rajasthan, and the property at para number Roman 3 is situated within the territorial jurisdiction of the district.
Just wait, the para 6(1)(2) is good. And the property at para 6(3) is okay within the.
Within the territorial jurisdiction of District Judge Jaipur, Rajasthan. At the time of death of the testator, left behind the following legal heirs: Shri Amarchand Sethi, son; Srimati Manju Sethi, daughter-in-law; Shri Sandeep Kumar Sethi, grandson; Shri Pankaj Kumar Sethi, grandson; Srimati Ritu Sethi, wife of Sandeep Kumar Sethi, granddaughter-in-law; Srimati Ritu Sethi, wife of Pankaj Kumar Sethi, granddaughter-in-law; Miss Labhaya Sethi, great-granddaughter; Miss Ditya Sethi, great-granddaughter; Master Harvashan Sethi, great-grandson. In view of the above facts as stated above, the petitioner has prayed for granting probate in respect of the said will, the beneficiary being Srimati Manju Devi Sethi, wife of Shri Amarchand Sethi. Upon receiving the petition with the above pleadings, this case was registered. Notices were published in the local newspaper and posted on the notices board of District Court Sikar, District Court Jaipur, District Court Collector Sikar, last resident of the testator, Deputy Commissioner Office Dimapur, and District Court Dimapur. No objection has been received from any quarter. In the course of hearing, the petitioner has examined himself as PW1 and filed his deposition affidavit in supporting the pleadings in the petition and proved the probate petition as Exhibit P1. His signature in the petition as Exhibit P-1A, copy of the will as Exhibit P2, death certificate of the testator as Exhibit P3, notice in the Morang Express as Exhibit P4, receipt of notice from District Sikar, Rajasthan as Exhibit P5, compliance report from District Court Sikar as Exhibit P6, receipt of notice from District Court Jaipur as Exhibit P7, and photograph of notice board at District Court Jaipur as Exhibit P7A, receipt of notice from District Court Sikar as Exhibit PA, photograph of notice at last residence of testator at Exhibit P9, photographs of notice at Deputy Commissioner's Office Dimapur as Exhibit P10, photograph of notice at District Court Dimapur as Exhibit P11. Shri Amarchand Sethi, son of testator, was examined as PW2. Shri Manju Devi Sethi, daughter-in-law, was examined as PW3. Shri Sandeep Kumar Sethi, grandson, was examined as PW4. Shri Pankaj Kumar Sethi, grandson, was examined as PW5. Shrimati Ritu Sethi, wife of Shri Sandeep Kumar Sethi, granddaughter-in-law, was examined as PW6. And Shrimati Ritu Sethi, wife of Pankaj Kumar Sethi, granddaughter-in-law, is examined as PW7. All the PWs have filed their depositions in affidavit, supporting the pleadings in the petition, and have made averments that they have no objection to the grant of probate in favor of Shrimati Manju Devi Sethi, wife of Shri Amarchand Sethi. I have perused the case report, the evidence of the PW1, and the other PWs and the document. The evidence of the petitioner has remained unrebutted in absence of any cross-examination. It is therefore proof that the testator, namely Shrimati K.C. Devi Sethi, wife of Bhajanlal Sethi, executed a will dated 21/10/2019, bequeathing the lands, plots, movable properties as described in the will to her daughter-in-law Shrimati Manju Devi Sethi, wife of Shri Amarchand Sethi. Execution of the will is duly proved by the attesting witnesses, namely Shri Sanjay Kumar Sethi and Chandu Kumar Agrawal. There is no other material to doubt genuineness of the will. There is also no other material to show that after execution of Exhibit P2, the testator has executed any other will. It is clear that in the instant case, the petitioner has been able to satisfy this court to the due execution of the said will as per the requirements of Section 63 of the Indian Evidence Act, read with Section 868 of the Indian Evidence Act, and the same is genuine will. Considering all the above, it is declared that the will dated Itne is the last will of the deceased testator Shrimati K.C. Devi Sethi, wife of late Bhajanlal Sethi. Let a report of valuation of the property involved in the said will with regards to the plot of land, movable property bequeathed in the will be filed. The petitioner shall take necessary steps for the same. After receipt of the report of the valuation, the probate be granted to the petitioner in respect of the property described in the will under Section 278 of the Indian Succession Act 1925 on submitting court fee stamps of requisite value. Let the original will be returned to the safe custody forthwith in the office of District Judge Dimapur, Nagaland. The bench assistant Peshkar shall do the needful immediately in this regard. Petitioner is thus entitled to get the profit of the aforesaid bill as executor under the will, subject to the payment of court fees on the value of the property likely to come in the hands of beneficiary as per the present valuation notification of the concerned department issued probate case is disposed of. Now, your lordship, the probate proceedings in respect to a will cannot be granted mechanically because it is such a document that which comes into operation after the death of a person. And a person cannot come in witness box after his death to prove. Therefore, the Honorable Apex Court, I will cite those judgments, has held that the courts have to be very careful, see the situation, see the facts. Here was a case before the court that on 21/10 a will is executed, 23rd it is registered, and 24th the lady is dying. What is the state of mind of the lady? Not proved anywhere. Whether she was ill, whether she was in the perfect situation of mind, nothing has been proved. Now kindly see whether the probate proceedings which were initiated were at all maintainable. For that purpose, my lords, I will show the proceedings which were initiated. If the proceedings which were initiated were not in compliance of the provisions of the Indian Succession Act 25, no probate could have been granted. Court was under bounden duty to see the act, whether the application submitted by the executant petitioner before the probate court is in compliance with the provisions of section of the Indian Succession Act. For that purpose, your lordship may kindly see the probate application which was filed. Kindly have perusal to the probate proceeding. It is annexed to page 27. Yes, this is the application submitted by the executant Pradeep Jhanjri before the principal district and session judge Dimapur. Now, if your lordship will see that there is no verification of this petition, kindly see at page 31. it is the last page, there is no verification. Rather, there is an affidavit at page 32, which is again without verification. You know, for that purpose, my lords, whether verification is necessary or not, I will directly take your lordship towards the provision. Section 280 of the Indian Succession Act, 1925. Section 280. I will also put it.
Yes, read.
Petition for probate, etc. to be signed and verified. The petitioner for the probate or letter of admission shall, in all cases, be subscribed by the petitioner and his pleader, if any, and shall be verified by the petitioner in the following manner, namely, I, so and so, the petitioner in the above petition declare that what is stated therein is true and to the best of my information and belief. This is missing. Now kindly have perusal to the next section, which is very relevant. Section 281.
Section 281. 281. Okay.
Now this has to be verified by one of the attesting witness. Kindly see. Where the application is for probate, the petition shall also be verified by at least one of the witnesses to the will when procurable. The word procurable has been used, my lords. If both are dead, then it cannot be procured. Here both are alive. Both are alive. Because they have filed the affidavits in the proceedings, not at the beginning of the proceedings. And I'll show those affidavits. Your lordship would be surprised that affidavits has been oathed on third and the order has been passed on second. I'll show them. Where the application is probate, the petition shall also be verified by at least one of the witness to the will when procurable in the manner or to the effect following, namely. Again, the procedure has been shown. I, CD, one of the witness to the last will and testament of the testator mentioned in the above petition, declare that I was present and saw the said testator affix his signature or mark thereto, or that the said testator acknowledge the writing annexed to the above petition to be the last will and testament in my presence. Now, if your lordship will see the petition, Annexure 2, completely it is missing. There is no verification of any of the attesting witnesses before the trial court. So there is complete violation of these two sections. Though there is violation of section 284 also, which provides that a caveat should be issued to every interested person. Two 283 and 284 may kindly see. Powers of district judge. Subclause C. Issue citations calling upon all persons claiming to have interest in the estate of the deceased to come and see the proceedings before the grant of probate or letter of provision. Now, I will show, my lords, that the respondent knowingly well that litigation in respect to these wills is pending at state of Rajasthan district seeker, not informing the probate court that let the citation be issued, as this person is having interest in the property and he's filed the suit.
Petitioner is the executor.
Petitioner is executed. Petitioner was also party in that suit.
Oh, which is pending in Rajasthan.
In Rajasthan. I'll show I filed the copy of that suit. There is a stay order operating in the court before the culmination of these probate proceedings. That order your lordship will find.
No. Just
Yes.
slow. Stay ordered in respect to what?
I had filed a suit on coming to know immediately about the will. What has happened, my lord?
About this particular will, about the will which is actually challenged.
Yes. This will, what happened, my lords? I had two wills of 2010 and 2012, which were registered at the state of Rajasthan. They were in Hindi language, of which the lady was knowing well the Hindi language. She was not knowing English. If your lordship will see the signatures are put in this.
The lady means the testator here.
The testator, Kesri Devi.
That will in Rajasthan.
Yes.
Was also executed by the same testator.
By the same testator. Registered wills. In respect to two very properties.
And that was revoked.
That revocation is also pending, civil court pending, and stay has been granted. That revocation is also post one. I'll demonstrate everything before you.
Stay against the revocation.
Yes. The stay is that no records should be changed, property should be kept intact. In spite of that stay order, they don't bring this fact to the knowledge of the probate court that litigation is going on. They went upon to get this probate issued in their favor. I think so. Next time is there.
We'll see that too.
Yes, madam. Very grateful. Madam.
Computer section, court will see that too.
That's it.
Yes,
We are under strict surveillance. We are under strict surveillance by our clients.
We cannot say that the matter did not reach.
Yes.
Because if we is reported, the matter we will not play it.
Naturally, naturally. We'll start only at
We have practically no case of this nature. Practically, we have no case of this nature. So I will also have to consider it. Because actually, this is also testamentary appeal, one of 2022. And after that, we don't have. Even to 2023, I have not find any testamentary appeal.
This is the first in the Kohima bench.
Yes, this is the first in the Kohima bench. So I think we should all be careful
Try
when
my best to assist my lords.
yes, yes.
Try my best. Yes,
So
ma'am.
continue,
Yes,
continue.
ma'am. I was on section 283 of the Indian Succession Act,
To
83. I had referred to 79, 280, 281 earlier.
section
283. Now it provides that subclause 3,
283,
subclause 3,
subclause,
C, I'm sorry, C,
subclause 3 or
C, 1C,
1C.
right.
Okay, just wait.
Issue citations
Just
following
wait.
upon
Section 283.
1. C.
Okay.
Issue citation following upon all persons claiming to have.
Issue citations.
Citation.
What does it mean? Issue.
Citation in notice. Here the citation is mandatory provision of a notice. A
Okay,
person
okay.
should know that the probate proceedings have been initiated. One is a general citation, which is in the form of paper publication. It is in the form of special citation.
Okay, let us read this.
Yes. Issue citations following upon all persons claiming to have any interest in the estate of the deceased to come and see the proceeding before the grant of probate or letter of administration. So a citation ought to be issued to every person who has interest in the property of the deceased. Now, if your lordship will see.
What is the relation between the appellant here, correct?
That's what I'm
Appellant.
submitting. The appellant is the son of deceased brother.
And the executant is?
Executant, we don't know who is testator, the lady.
No, I am concerned about the executant.
Executant is a third party.
Is a third party. Pradeep Jhanchiri.
He is merely an executor. He does not have any interest on the property. He is not a beneficiary. He is nothing. The testatrix, while died, while made the will, she has entrusted this Pradeep Jhanchiri, who is a joint community leader in Dimapur, to execute the will after her death. He does not have any interest in the property. He does not.
Yes, Leonard Counsel.
Yes, please.
Who has the knowledge about the proceedings at Rajasthan?
Both. I'll show this before you.
Both means
Both means the beneficiary as well as the notice was issued to the executor also. We had made both of them party. What has happened? I'll explain. What happened? That as
No, just for my knowledge.
Yes, yes,
Just for my knowledge, I just want to know whether you have.
Yes.
Whether actually the appellant has personal acquaintance with the executor of the will.
No, we don't have personal acquaintance with the.
But you have actually, the Rajasthan court has issued notice to the executor as well as the beneficiary.
What is the reason behind it? I'll let you know. As soon as she died, on the basis of the two wills in favor of the appellant, that is of 2010 and 2012, he went before the municipality seeker for issuance of patta in his name, on the death of the testator. Because two wills in respect
in the name of the appellant.
In the name of the appellant. Before the municipality, that is an authority to transfer and issue patta after the death.
Okay.
During that proceedings, this Manju Devi Sethi filed an objection online. Saying
in that case.
In that proceedings. That was not a case, it's a proceeding before a quasi-judicial authority. That is a municipality.
Mr. Paul, there seems to be separation of facts in your petition. That is what I can gather.
Your Lordship,
And if there is separation of facts, this court need not go into the merits.
Your Lordship.
This court can just dismiss the order passed by the probate court.
Your Lordship, I'll satisfy the honorable court. they are coming with the plea that. They are coming with the plea that.
I'll hear you. Okay, I'll hear you. So those proceedings, when we started, because in Rajasthan, my lords, probate is not necessary. I'll cite the judgments of the Rajasthan Court. In our state of Rajasthan, as soon as the will is executed, if it is a registered will, the death take place, the wills come into existence, and on the basis of the will, the rights are transferred. There is no necessity of obtaining the probate.
Okay.
So as soon as she died in 2021, immediately my party, that is appellant, on the basis of the two registered will which are in Hindi, registered at state of Rajasthan at Sikar, applied before the quasi-judicial order. There, for the first time, she makes an online application and objection without mentioning the date, and nothing was mentioned by her about the will. She only said that there is a will in my favor. Therefore, the patta shall not be issued to the appellant.
So the authority is there at Rajasthan.
At Rajasthan. Subsequently, his counsel, because all these, the property in dispute was under the tenancy of the tenants.
Correct.
So, through counsel, she got a notice issued to the tenants, mentioning about the will. There, for the first time, the date of the will came into existence.
That means, if I can understand correctly.
Yes.
There are two wills.
There are three wills.
No. One in favor of the appellant.
Yes.
One in favor of the beneficiaries of the will executed at
Yes.
Dimapur.
Rather, two wills in my favor.
Two wills.
Two different properties. Because there were 4 properties.
And which are the properties of the Dimapur will, which is mentioned in your will?
My properties are not in Dimapur.
No. The testator has executed a will in Dimapur.
Right.
Correct.
Right.
Over certain properties at Rajasthan. Correct. The testator has also given you a will for the same properties at Rajasthan.
At Rajasthan.
Correct. That is why I am asking you to point out from the will executed at Dimapur.
Yes.
Which are the properties which were executed in your favor?
1 and 2. Property number 1 and 2.
Property number, just let me, this is for my knowledge.
Yes. Definitely, I have to clarify.
1 and 2.
1 and 2. Roman number at 1 and 2. If your lordship will see the will, that is at page 27.
Page 27, no? Yeah, taken me to this. Okay. Page 27 of the.
I'm sorry. It is page 42.
Page 42.
Annexure 4.
Just wait, okay?
Yes.
Page 42.
40.
So which relevant portion?
Yes, my lord. Relevant is an internal page 4, external page 45.
45.
The property number Roman 1.
Just wait. Property Roman 1.
I
This
do
is it start? Does it start with the word I do hereby devise?
Yes, this is.
Because some seal has actually blocked.
I do hereby devise and bequeath my land commercial purchase from Anandi Lal, Hukmi Rai, white registration dated 15/6/1967, situated at Shastri Nagar, Ward number 15, old in the main road of Ashok Vihar to Rani Sati Road, Tehsil Sikar, District Rajasthan, measuring 90 feet in north, 150 in south, 150 feet in east, in west, covered by book number 1, volume number 23, pages so and so, serial number itne.
So, learned counsel, the same property is reflected in your will.
My will. And the other second will, because I have 2 wills, that is in regard to property number 2, Roman 2. Right, sir? And those wills I have annexed. If your lordship will find my wills is as annexure 6.
Let us come to that afterwards. Your wills I will come afterwards.
Yes.
Let me first understand your appeal. Let us first understand your appeal. Then I will come to your will. So 1 and 2. 1 and 2. That means you have no dispute with 3.
3 and 4.
3 and
4.
Okay.
If 4 is a residuary clause, if your lordship will find. It's not in regard to any particular property, it's a residuary clause.
Okay, my land at, no. 3 says my land at Vardhaman Nagar.
This is 3. I'm saying 4 is residuary.
4 is residuary.
4 is residuary.
My share partner, MS Sensor, so 3 and 4, no dispute.
No,
Dispute is with regard to
Roman 1 and Roman 2. And more particularly in regard to Roman 1, because I will demonstrate that Roman 2, after execution of will in my favor, was sold by her in entirety.
Was sold
by Kesari Devi Sethi herself. After making a mall over there, shops were constructed and she sold the property by registered sale deed.
What were you doing?
So I was not required. See, a person who is the owner of the property, even after execution of a will, she can sell the property. There is no dispute. She sold the property in her lifetime. I could not have objected. Why should I object? That was
no. This property at serial 2,
yes,
was also bequeathed to you.
Yes.
So why were you keeping silent when she sold?
Because she was the owner of the property. She wanted money. ठीक है, मैं ये वाली नहीं दे रही हूँ आपको, मैं इसको बेचना चाहती हूँ, बेच दो. She sold the properties. We never object. The property. That's what I'm submitting. Once she has sold the property, she knew very well this will is forced for the reason that it does not mention all those sales. They were even not knowing what properties are there existing in Rajasthan, and got the sign clandestinely.
No, if you are saying, if what you are saying is right.
Right.
If the Manju Devi
yes,
did not even know what were the properties bequeathed at Rajasthan.
Yes.
How will she sell the property?
Sale by, not by Manju Sethi, by Kesari Devi, original testator. She had sold in her lifetime.
After this property was bequeathed to you?
Yes. 2 properties were bequeathed to me by 2 separate wills. Those 2 wills I can refer. One is of 6/10/2010. Other
No, just wait. Let me just get your keys. So this property at serial 2, which was bequeathed to you by the testator, was sold after the execution of the will.
In my favor.
And why have you remained silent?
Sir, because for the reason, suppose my father wills me 4 properties during his lifetime. But at some point of time, one property he wants to sell for his own need. He can certainly say, I can only become the owner after the death.
Okay, then one issue.
Become the owner.
Whether there was one will executed in your name or 2 wills.
2 wills.
2 wills.
2 wills.
2 different wills.
2 different wills of 2 different separate properties.
So you should have no grievance even with regard to 2.
I am saying I am no grievance, but what I am saying, to show that this is will is forged when executed, because when the property was sold by her, if a person is not known,
what do you mean to say is that when the testator had sold this property, how can she bequeath this property
again in 2019?
Manju Devi?
Yes, and this shows the entire malafide and the act of the beneficiary and the executant. If your lordship
just wait, let me note this, because actually I think we should be law, of course, that's a different issue. We should be well conversant with the facts.
Facts. Very well, sir. Very well. I deeply applies.
Manju, her name is Manju.
Manju Sethi, wife of Amarchand.
In which year the property was sold?
Property was sold during the period of 2012 to 2019. Well, during 12 only, it was sold. Immediately after bequeathing of the will in my favor, she sold it because she was alive. She was in very good condition at that point of time.
In which year?
2012.
2012. And this will is dated. This
2019.
impugn will is dated
2019.
2019.
It is dated 21/10/2019, registered on 23/10/2019, death on next very day 24/10/2019.
Okay, so you have no issue with even the property at serial number 2.
Because that property is sold, but it shows
Okay,
it
okay.
goes to the fact that if a person herself has sold the property,
Yes,
she
now you are telling me that you have 2 separate will
yes, my lord.
executed by the testator
Yes,
for the property at serial 1
and 2.
and different gifted for the property at serial for the property at serial 2. So you have no issue with 2.
For the reason
Your reliance in 2 is only to show that when this property has been sold during the lifetime of the testator, how can actually this property be again bequeathed to Manju Devi
by
in a
a will of
subsequent will?
2019. She was not even aware of what is remaining of Manju Devi. All things have been made. I will show before your lordship how these facts have been.
No, I'll slowly come.
Yes.
I'll slowly come. Let me first get the basics.
Right. Now, immediately on coming to know about the 2019 will, when she made an online objection and a notice to my teenage saying that I have a will, I immediately filed a suit for cancellation of the said will at Seeker.
Means your tenant at the property in serial 1.
One. Now kindly see the order of the.
Just wait. What was your submission now?
That
Online complaint.
objection she filed for objecting that on the basis of the will of 2010 and 12, no right should be given to the appellant. She approached the municipality by making an online objection.
So consequent to the online objection, you file a suit.
Consequent to online objection as well as notices to my tenant, because the date of the will was disclosed by her in the notices, not in the online objection.
And
notices to tenant under section 9 of the Rajasthan Rent Control Act. And virtually that notice was to me only because she treated me to be a tenant. Because I was occupying the property. And only after the death, I would become the owner.
You filed the suit at Rajasthan court.
Yes, at Sikar, district Sikar. And the suit was filed, my lord, so we kindly note the date is very relevant, on 2/1/2021.
The suit. Where have you stated? You just tell me. Okay.
Yes, the
Suit
suit
was
was
filed?
filed on 2nd of January 2021.
2
January
1
2021.
2021. At
District Principal District Court, Sikar. And kindly have perusal that suit. I have annexed a copy of that suit.
Sikar.
Sikar.
SI
SIKAR. State of Rajasthan. I will come to the suit subsequently. Kindly have the order passed by the district court Sikar as an interim order. It is annexure 3, page 39.
Annexure 3, page
39.
39.
39.
Oh.
It's in Hindi and the translation is on page 41, my lords.
Page 39. This is the order passed by
the district court Sikar. The typed copy your lordship will find at page 40. 27/1/21.
Okay, please read the order.
Kindly see page 41. Counsel for the applicant present. Advocate Shri Mahesh Kumar present on behalf of non-applicant number 1.
What does it mean? Non-applicant.
Non-applicant, sir, what happens in our state? Suits have two parts. One is the suit under Order 7 Rule 1. The other part is the temporary injunction application, which is filed under Order 39 Rule 1 and 2. So in suit, we call plaintiff and defendant.
Correct.
And in the temporary injunction application, we always say applicants and non-applicants.
Oh, applicant
and non-applicant.
The opposite party is addressed as non-applicant.
The opposite party is a non-applicant. Some places it is called opposite party.
Okay. Okay.
So counsel for the applicant present. Advocate Shri Mahesh Kumar present on behalf of non-applicant number 1. Now I will show from the suit that non-applicant number 1 is the Manju Sethi, who is the beneficiary of the gift. So his counsel had appeared on that day.
Just wait. Yes, please.
For non-applicant number 3, that is the municipality, Shri Bhojraj Singh.
Non-applicant number 3?
3 was the municipal corporation.
Okay.
Which was the quasi-judicial authority which was required to issue a patta in my favor.
Correct.
So advocate for Shri Bhojraj Singh was present. And someone of non-applicant number 2. Non-applicant number 2 was this executant, that is Pradeep Jhanjri. His summons were not written.
Okay, yes.
I will state the reasons also.
So non-applicant number 2 is the executant in the present impugn will.
in the,
Okay. Okay.
what was further held? Applicant produced 8 photocopy documents along with the list. 1 and 3, that is the counsel for the municipality and counsel for Manju Sethi, sought time to file reply to TI application. Counsel for the applicant praised for interim status quo.
Applicant produce 8, just wait, okay?
Yes, yes,
Applicant produce 8 copy documents
yes.
along with the list.
List.
Means
The documents were placed. There is a provision that the photos, in the suit, my lords, all the original documents are annexed. In the temporary injunction application, the photocopies are placed. So all the photostat documents, 8 documents were placed to show my will was placed, their will was placed, other documents were placed which were showing these signs of Kesari Devi. Those documents were placed.
what is 1 and 3 sought time to file or non-applicant 1 and 3?
Non-applicant means non-applicant 1 is Manju Sethi, non-applicant 3 municipality. They wanted time to file reply.
Okay,
That they want
yes.
to file a reply to the stay application.
Okay.
Now, counsel for the applicant prays for interim status quo. Heard both the parties, perused the report. Looking to the facts and circumstances of the case, the parties are directed to maintain status quo with regard to cite and record till next day. File is posted for reply of TI on 3/3/2020. So status quo.
Reply of TI.
TI, temporary injunction application.
Okay.
Which is under 39 Rule 180.
The parties are directed to maintain status quo
with regard to cite and record.
So what will be the result of the status quo?
This status quo will result that no thing could take place in respect to the disputed property.
When is this order passed?
On 27/1/21. Before the probate order. And I'll show that how they have concealed all the facts before the probate proceedings. I'll show from their affidavits.
Okay, so 27/1/2021 was passed before the probate order was passed by the district judge, Dimapur.
Now,
so what you mean to say is that in the probate proceedings, while filing the probate proceedings, the petitioners therein already had the knowledge that this case was filed against them at Rajasthan.
And the status quo order is there, not disclosed. I'll show. Subsequent to this status quo order, they have filed the affidavits before the court of Nagaland for in probate proceedings, not disclosing it. During this pendency, I filed an FIR in respect to this forged will in Rajasthan. That FIR was filed, the lordship may kindly note, on 29/1/2021.
So after this 27/1/2021, they had taken steps to file the probate application.
No, probate application was filed prior to that, but proceedings were continued. Probate application was filed on 7/10/20.
Okay, okay. So the
Proceedings were filed on 7/10/20.
first.
And probate.
So what you mean to say is that actually this status quo order was passed during the probate proceedings
Pending.
in Dimapur.
In the. This fact of pendency of probate proceedings was not disclosed before the seeker court. When the status quo of order of 27/1/2021 was passed, they could have said that already the probate proceedings are pending. They never disclosed because they knew that as soon as they informed the other party, the party would take part in the proceedings. To avoid that I may not take part in the probate proceedings, it was not disclosed. For this, I filed an FIR also. Kindly have the date of that FIR.
Just wait, just wait. So what you mean to say is that this probate proceedings which was pending before the Dimapur court was not disclosed before the court had registered.
At seeker.
And this was with the intent to debar you from taking part
In the proceeding.
in the proceedings.
As an interested person.
Okay, then what happens?
Then on 29/1/2021, I lodged an FIR before district seeker.
On
29/1/2021.
29,
1,
1,
that is January, 29
29, 1,
2021.
2021.
One.
FIR lodged.
FIR laws pertaining to this will to be forged.
Against the will executed at Dimapur.
Yes. She
Just
filed.
wait, just wait.
I'm sorry.
Okay.
On
Yes.
FIR having been filed, she filed a 482 proceedings before the High Court of Rajasthan Bench, Jaipur, for quashing of the FIR.
Okay. That means the beneficiary in Dimapur.
Yes, yes.
Manju Devi.
Manju Sethi.
Manju Sethi. What is the fate of this case?
The 482 was rejected by the Honorable High Court, looking to the contents of the FIR and the investigation up to that date, which
Rejected by which order? Do you have the copy of
Yes,
the
I placed that order.
rejected by which order?
Annexure 5, page 53.
Rejected by Annexure 5, page
Page
53.
53. If your lordship will see.
Page 53. Oh,
It starts
page
from
53,
54.
page 53.
Page 54. Manju Devi and Amar Chand were the petitioners.
This is order dated.
Order dated 4/1/2022. Petition has been filed in 21. If your lordship will see the number of the petition. It will demonstrate that the petition was filed in 21. I am saying so because for the reason that just one day before this order, they submitted the copy of the order of the probate. For that was the first time, that is 3/1/2022, when we came to know about that behind our back, concealing all facts, the probate has been obtained. In spite of
This order was passed 4/1/2022.
22.
And then what did you say? What is that relevance? On which date? You came to?
On just day one before, that is 3/1/22.
3/1/2022.
They place documents, taking copies from the court.
Which court? Dimapur court.
Dimapur court. The document of probate order. Court has considered that. It has come.
Copy of the order passed by the probate court.
Probate court. Court has considered that at page 55.
This was handed over to, the copy of the order was handed over to
the Honorable Court.
That means the district court?
No, High Court in 482 proceedings for questioning of the FIR. Prior to that, there is not even a whisper or disclosure.
And it was only then you came to know about the probate proceedings.
And then we challenge immediately before your lordship.
So on coming to know about the probate proceedings of the Dimapur court, you filed this appeal, challenging this.
The court, in spite of producing that probate, considering all the aspects, rejected their petition. Your lordship may kindly see page 55 of the order. The very next page. Yes, last 10 lines may be keen. The another aspect of a case as shown. Your lordship have got it?
Yes.
by the learned counsel for the petitioner. This was for the first time he was trying to show that the probate has been granted, is that a bill in question has been submitted with the civil court, Dimapur, Nagaland, where probate proceedings has been undertaken. The probate court, after making incisive probe in the matter, has granted probate in favor of the petitioner. Thus, further probe for the same document by a police officer would not be required, and thus contents of the investigation in the FIR could be nothing but an abuse of process of law. In spite of this fact, considering all the arguments at page 56, and 57, considering that there are two wills in favor of the complainant. One will is this, looking to the signatures appended with all the documents which are different in nature, held that the FIR cannot be quashed.
Which para you are reading?
I am reading, Maharaj. My arguments are at page 56, last 3 lines. Learned counsel for the complainant. Last 3 lines at page 56. Learned counsel for the complainant drew attention of this court towards some registered document, genuineness of which has not been disputed, which were executed by the deceased Kesri Devi in favor of several persons, including 2 wills in favor of complainant Narendra Kumar. A cursory look over the signature appended on the undisputed documents and the disputed will persuade any prudent man to hold that the matter requires investigation. Till date, the original bill has not been taken on record by the agency, so that the same can be sent to for comparison to the handwriting expert. This was my argument. Then court heard both parties and declined to interfere in the FIR. This is last paragraph. The meticulous appreciation of material is not required to be done at this stage. The bare provision of the report discloses commission of cognizable offense which requires to be investigated. After going through the entire material available on record and aptly guided by the judgment submitted by the counsel, this court is of the considered view that the matters requires investigation.
Okay.
Now, I have shown 3-4 causes before your lordship. That violation of the provisions of Indian Succession Act, the violation of citation having not been issued, the violation of not issuing the citation to me, not disclosing the fact. It is a very interesting provision under the Indian Succession Act. It is 263 may kindly be seen.
Two
63. May I read with your lordship permission?
Yes, please.
The grant of probate or letters of administration may be revoked or annulled for just cause. There is not requirement of any lengthy hearings or lengthy causes. Just cause. Now, what are the just causes? Your lordship may kindly see in the explanation.
Just wait.
In explanation A, if your lordship will see, the proceedings to obtain the grant were defective in substance. So how they were defective, I have demonstrated that neither it has been verified by the executor, nor it has been verified by one of the attesting witness, which is mandatory provision. So if your lordship comes to the conclusion that it had defects, it can be annulled and removed. I fall under B also. Kindly see the B. B for Bombay.
Yes.
The grant was obtained fraudulently by making a false suggestion or by concealing from the court something material to the case. I will demonstrate that before the probate court, they concealed the fact of pendency of the suit, the stay order. Nothing was disclosed before the probate. So on that count also, probate is liable to be rejected. C. The grant was obtained by means of an untrue allegations of a fact essential in point of law to justify the grant. So it is based on untrue facts because they have not brought the correct facts before the probate court. Just only on just cause, I will cite a judgment in the end that Supreme Court says if the citation has not been issued, the probate can be annulled and revoked. Now I will here show that in what manner the probate court works. That is also very important to be touched by my notes. The probate was filed on 7/10/2020 undisputed, which had full defects as already stated before your lordship, not in line with the provisions of Indian succession. Thereafter, my lords, kindly see the proceedings of the court. How this probate has been granted. I have placed on record the last order sheet of the probate. Kindly have period to Annexure 10, page 84 to 85. The lordship will see the first date, that is 25/2/21. Parties absent. Refix on 2/3/2021 for evidence of petitioner and then PWs if any. So till 25/2/21, no evidence of any nature was there before. Right from the date of filing of the petition. Now kindly see the next order sheet. On 2/3/2021, everything happens in one day. 2/3/2021. Petitioner and PWs present. Council present. PWs have filed their depositions.
No, whether this 25/2/2021 was the first order.
No. First order, the probate was filed on 7/10/20. This was the second last order.
What you mean to show is that till 25/2/2021, no evidence was adduced.
In one day, all the evidence were taken on record. And on the same day, the order was passed.
The probate order was also passed on 2/3/2021.
Now,
Yes,
Your Lordship may kindly appreciate, I'll show from the order that how the affidavits of attesting witnesses have been taken into consideration.
Okay.
For that, my lords, I would like to refer the impugned order. Kindly have perusal. It starts from page 22 and I refer page 25. Para 12 may kindly be seen. May I read with your lordship permission?
Yes, wait.
Para 12. Page 20.
Page 25.
Page 20.
Yes.
Shri Amarchand Sethi, son of the testator, was examined as PW2. Shri Manju Devi Sethi.
Who is Amarchand Sethi?
Husband
of the beneficiary?
Sethi. Daughter-in-law was examined as
Just wait, just say Sri Amarchand Sethi.
was examined as PW2.
Son of the testator. Okay. Okay.
Srimati Manju Devi, daughter-in-law, was examined as PW3. She is the beneficiary. She has been examined.
Yes.
Now it is necessary to see when the affidavit has been filed on 2/3/2021. The stay in January 21. She ought to have disclosed before the probate court while filing in the affidavit that, my lords, the proceedings are pending. She does not disclose. I'll show the affidavits typographically, verbatim, word to word, same fill in the blanks type affidavit. If your lordship will see, up to PW7, the court names all the PWs. Correct? In para 12. Now kindly come to para 14.
Yes.
Execution of the bill is duly proved by the attesting witnesses, namely Shri Sanjay Kumar Sethi and Chandu Kumar Agrawal. Now I point out before your lordship, they have not been numbered. If all the evidence witnesses were there on the same day, that is on 2nd of March 21, court has recorded the numbers of all witnesses, PW2 to PW7, but not recorded the numbers of these two attesting witnesses. And I'll demonstrate before your lordship that there was a reason behind it, that it was not there with the court and could not have been numbered.
Yes, please.
These affidavits I have placed on record, your lordship, as annexure. As annexure. Just a moment. Just give me 1 minute. (27 to 38).
27 to
38
of your petition.
Yes, sir. Yes, sir. These are not those affidavits. I'll just give the date of the affidavit. This is at page 80. These are annexure 9. Page 80.
Page 80, these are the deposition.
Deposition of the two attesting witness whose numbers were not mentioned in the order sheet, whose numbers are not there in the order. And the probate court has left. Kindly have parallel to page 80. This is the deposition of Sanjay Kumar Sethi. Have you lordship got it? Age 53 years. Kindly come on the next page. Last paragraph. I further declare that the statement made in this affidavit are true to the best of my knowledge and belief, and I have signed this statement of affidavit on this day of 3rd March 2021. Kindly note down.
3rd March?
March 2021. The order is passed on 2nd of March 2021. The affidavit is shown on 3rd March 2021. Next day.
Let us see. The order is passed on 2nd March.
of March. That's why he could not number those affidavits on 2/3/2021, because these affidavits never came into existence on 2nd of March. And notarized on 3rd of March. Kindly see have the signature of the notary putting the date. These are the attesting witnesses. The next is the second attesting witness at page 82. Bhai Shri Chandu Agarwal, age 55 years, so and so. And in the next page, if your lordship will see, again, oath on 3rd March 21 and notarized on 3rd March 20. That's why I read the order prior to showing these affidavits. Had they been in existence on 2nd of March, he would have numbered them as PW8 and PW9. In order sheet, not mentioning what affidavits have come, PWs have come. Now your lordship may kindly appreciate the fact on merits. Whether, because court says it has been proved as per provisions of the Indian Evidence Act. Now, what is the first and foremost thing to be proved in a will by the attesting witness? That the testator signatures scribed at so and so place from A to B were signed by the testator in my presence, and I have signed in their presence. foremost thing for proof of the will is testator's signatures have to be proved. None of the attesting witnesses have proved the testator's signature. Rather, they have proved their own signatures, that we have put the signatures as P1C and P2C.
Which provision? Which provision?
63 and 67. And we have earlier section 63 of the Evidence Act.
Evidence.
Evidence Act. Not 69, I'm sorry. This one. 67. 67 of the evidence. May I read with your lordship permission?
Yes. 67.
Proof of signature and handwriting of person alleged to have been signed or written document. If a document is alleged to be signed or have been written wholly or in part by only person, the signature on the or the handwriting of so much of the document as alleged to be in that person's handwriting must be proved to be in his handwriting. So if signatures are required to be proved, then one has to come in witness box and say that the signatures at place A is of the person who has signed this signature.
There is a procedure to prove the will.
Right.
What is that?
67 and 68
Of
the Evidence Act may finally be seen.
No, Evidence Act, this is general.
Indian Succession Act 63 and 68.
63
is how the execution of the will take place.
There's a provision as to how a will should be proved.
There's a specific provision. I'm just not getting it. The evidence had made the provision of proving a will. Just a moment. 68.
68.
Page 160.
Evidence Act.
Evidence Act. You're taking it to different because you're going to proof of execution of document required by law to be attested. Attestation is necessary for a will, and how the attested document is to be proved is under section 68. If a document is required by law to be attested, it shall not be used as evidence until one attesting witness at least has called for the purpose of proving its execution, if there had been an attesting witness alive and subject to the process of the court and capable of giving evidence.
No, the attesting witness has actually given the.
What attesting witness has given? That I had signed the will. He has not given the witness that on the will A to B are signatures of Kesri Devi. Kindly have that proof. Kindly see I am reading this 68 read with section 63. Kindly see how the signatures have to be proved. That's why I read section 63 also.
The secondary evidence.
No. 63 of the 67.
67 of what?
67 of Evidence Act. Proof of, I just read over to my lords. 67 of Evidence Act. Proof of signature. How the signatures to be proved? Merely attesting witness coming in witness box and saying, I have signed this will and my signatures are at place A to B is not sufficient.
No, there is a specific provision as to how a will is to be proved by the attesting witnesses.
Well, it's only 68.
I've come across, but
It's 68 only. Every attested document, because attestation is mandatory as per section 63.
proof of execution required by law to be attested. If a document is required by law to be attested, it shall not be used as evidence until one attesting witness at least has been called for the purpose of proving
Its execution. How the execution will be proved?
Let us see the statement.
Kindly see this statement. Page 80. That I am one of the witnesses in the last will of late Srimati K.C. Devi Sethi, bench of late Bhajanlal Sethi. On 21/10/2019, Srimati K.C. Devi Sethi executed her last will and testament, wherein Shri Pradeep Janjali has been appointed as executor of the aforesaid will of the testator, and the beneficiary of the will is Srimati Manju Devi Sethi, so and so, daughter-in-law of deceased testator. I identify the last will which is exhibited as P2, and my signatures in the said will is exhibit P2B. He has not said that the signatures of the K.C. Devi is at this place.
No, 68 only talks about proving execution.
Proving how execution would be proved as per section 63, signature. If the signature is not proved of a document, then the
Section 63 is secondary.
67. I'm sorry, 67. Until the signatures are proved on a will, no one has said that the signatures appended on the will is of K.C. Devi Sethi. That's why the verification was required mandatorily. If first you verify in the petition, as per section 281 of the Indian Succession Act, then you come in over and prove the execution and the signatures. Kindly see. Otherwise, why he has verified his signatures? He has verified that my signatures are from this place. Your Lordship may kindly see the will which I have placed. That will your Lordship will find at page 42 to 52. And at 52, the signatures of the attesting witness, they say we have signed it, but not K.C. Devi's signature. If the Lordship will see the record, no one has proved the signature of K.C. Devi. This is the certified copy.
Do you have a citation under that spec?
But I'll produce different citations. I'm coming to each and every point that in what manner this will has been executed, in what manner the probate proceedings have been initiated, in what manner the probate proceedings have culminated into an order. I just have to satisfy the conscience of the court only to the fact that whether a prudent man can apply the oath which has been taken on 3rd of March 2021 in the order of 2nd of March 2021. Your Lordship might say that it might be a typographical error. Had it been a typographical error, the numbers of PW1 would have been there. The court is putting the witness number as PW2 to PW7, but not putting the numbers on PW8 and PW9, which ought to have been placed. And the only reason could be that the document was not there while dictating the judgment. For probate to set aside and being declared annulled, just cause is to be seen by my lords. Learned trial court has not applied its mind, not seen the circumstances. Now I'll show further. The lady in the will has been shown as to be of 82 years in 2019, right? In the will of 2012, she is 80 years. How can she be 82 years after 7 years of that will? The declaration on which they relied, that the will was cancelled in the year 2012, that declaration is on record. The age of the lady is shown as 82 years in 2012.
Testator. The age of the testator.
And under this will, it has been shown as 82. After 7 years of declaration of that will cancellation, she does not add her age according to respondents. She remains 82. What my submission is, by impersonation or something which is required to be investigated, and for which the investigation is already pending, without that, probate in such manner ought not to have been done. And if it has been granted by concealing facts before the Honorable Court, then the appellate court has got every jurisdiction to annul and revoke that probate. Just for a cause, small cause, even if there is a deficiency in the filing.
Now, okay, just academic. What happens if the probate is annulled?
Is annulled. Then the suit which is pending before the seeker court, where in a civil suit, the very same will is under challenge, they will have a full right of opportunity to prove that will. I will have a right to disprove that will, that it has been fraudulently signed. The testator was not in the perfect mind of execution of the will.
That is only in regard to the properties it close to.
I'm not talking, my suit is for cancellation of the will. That's what I'm submitting. In which the stay order was passed on 27/1/21. The specific prayer is cancellation of will. Kindly see the suit, my lord. I have placed that suit. That suit your lordship will find with reply to affidavit of opposition I have filed. Kindly see the prayers of that suit. The suit I have prayed that the plaintiff prays for the following leaves. That the suit may be decreed in favor of plaintiff and against the defendant number 2, 1 and 2, as impugned will dated 21/10/2019, registered on 23/10/2019, may be declared illegal, bogus, ineffective.
Okay. So if this is annulled, then they will have all the opportunity to come and contest the case in the
Yes, and prove the will. If the will is proved, the property will go to them. If the will is not proved, found to be fraudulent, forged, and not able to prove the will.
Okay, we will continue.
And the suit was pending. They knew very well that the suit is pending.
We will continue. We will continue some other time. I think if too much goes into my brain, then I may forget everything.
I will require at least 2-3 hours, your lordship.
That's.
Because I have to go.
You are from Rajasthan?
From Rajasthan, Jaipur High Court.
Okay, then when can you give your presence?
Sir, somewhere in October.
No, because if I am to keep it partnered.
Okay. Then on next date, I will only submit my judgment because facts I have
No,
submitted.
but Learned Counsel, I would also request you,
Please.
as well as Mr. P.P. Paul,
Yes.
to actually give a gist of your this
Arguments and rulings.
arguments.
And
Rulings also, of course.
Both.
But actually the arguments, because actually we will have to deal too much on facts.
Right.
Yes.
So I would be requiring your assistance to give me arguments specific point wise.
Right. Definitely.
Okay, the arguments which you are making today,
Yes.
I have noted, but this is for my just this thing just
I
roughly.
will satisfy your lordship. I'll put it point wise.
Yes.
All the deficiencies with the page numbers. That
Yes.
This is lacking. This is
So
lacking.
can we have it next week again?
Sir, at least give me 15 days for preparing those arguments. Then after I'll come with my arguments.
No, you can even like come with the arguments after the hearing.
But better it would be I'll submit on that same day, so if.
Because after 2 weeks, I may not be here. The problem is that the roster system in this court.
That's right, that's I understand, my lords.
So if I'm not there, then keeping part had,
No, it will be, it will not.
it may even prolong for 4 or 5 months.
Right, sir. Then can we have it on 30th, my lord?
13th of
August, if it is not a holiday over here.
DB.
No, 13, we have a division bench,
29,
29, 29 years, it
it could be
is,
Tuesday.
it is possible. What about, will it not be convenient for you on 22nd?
22nd of August, my lord.
Yes,
My lord, it would be too short. I am coming from 2,500 kilometers away.
I know.
That is the only difficulty. 29 would be convenient. I will have 15 days of
29,
29.
you just check up the roster because my roster is only till 25th.
Till 25th.
Yes, after that, before, I think before 25th, we will get a new roster. But it is, there's no surety.
Then can it be on 21? Monday?
Make it on Tuesday, 22?
Yes, Tuesday. No issue.
Yes, we can continue hearing on 22.
But if your lordship may grant me one indulgence, can it be taken at particular time so that it may finish it off? Any time if your lordship can fix, otherwise what happens that it might not reach.
If you want the time of your choice.
No, I'm not.
Then,
I'm not your lordship.
No, I am actually like trying to accommodate you.
Right.
It will be on Thursday.
Okay, then time would be of my choice.
Because Thursday, normally we fix very less cases in Kohima.
Let it be on Thursday, sir, any Thursday. As convenient to me.
Not any Thursday, but
Then again, 24th would be the.
24th.
The roster would be the problem.
24th I'm here.
24th
I'm here.
Then it would be 20.
So 24th. Okay. I'm keeping it as partnered.
Right.
So if you are not here on 24th, then I release from partnered again.
No, I'll be there, sir, definitely. Until and unless something wrong happens with me, I will be there.
Actually, I am happy that at least while parting while going, my learned friend has referred the cancellation of the.
Yes, I will not.
Till now, he has not mentioned that one, but that is very that he has mentioned that earlier we were cancelled.
We will see to all this.
Yes,
all
yes,
points
yes.
raised. Okay. The third, Mr. Your good name, please.
Bipin Gupta, B for Bombay, BIPIN.
Bipin Gupta. Bipin Gupta.
Yes, my lord.
The learned counsel for the appellant. And Mr. P.B. Paul, learned counsel for the sole respondent.
Both respondents.
For both the respondents. Stop. Hearing remains inconclusive. Listed on 24/8/2023 as a part-heard item.
Interim may kindly be continued.
The interim order passed earlier shall continue till the next returnable date.
Much obliged.
Very grateful for the hearing. Very grateful.
Keep this, okay? Okay, then, thank you.
Much obliged.
Thank you.
Committee section, court 2 over.
Serious.